So, some of you know why we're here tonight, some of you don't. I know Pat doesn't, but all of us know how great attorney Pat is. He's been a criminal defense attorney for a long time. When I first came back in 2009, he was a great mentor to me. Had a lot of long talks with a lot of good advice, and now we're adversaries since 2018. And so I've always told him and everybody else, when I get in trouble, he's the attorney I'm going to hire. However, that's not why we're here tonight. Some of you may not know that way back in the 70s, Pat was a pretty good basketball player for Delphi Community High School. To my knowledge, he still leads Delphi with the most points scored. Now, this is before they had a three-point line. After the peach basket, but before the three-point line. Now, I did a little research, and I tried to find the number of assists he had, and for some reason, I couldn't find it. Well, I don't know if they didn't keep it, or he didn't pass it. I'll let him tell that story. So way back in probably the fall of 21, Susan read an article on Facebook or online somewhere, and said, hey, we should do this for Pat. Which, if you don't know Susan means, you should do this for Pat. So I made some telephone calls, we filled out a couple applications, did what we had to do, and I'm proud to be the first to announce that Mr. Patrick Manahan will be a 2022 inductee into the Sports Hall of Fame. Yeah! So, as part of that, Patrick, the Delphi Community High School was kind enough to give us a Delphi game ball, a ball that was used in an actual game last year. And we're going to pass it around. I want everybody to sign it. We've also got some flyers that talks about his statistics and everything that he's done in high school. There is a banquet in May where he's going to be inducted into a formal ceremony, and so we can pass some information about that around too if anybody's interested in going. But I want to make sure everybody signed this ball, and I signed it before I got here. And what I wrote is, Pat, number 34 on your jersey, but number 1 in our hearts. Thanks for all the long talks, the intense battles, and the cold beers. Congratulations on your induction into the Hall of Fame. Your friend, Nick.
I really, really appreciate everybody coming out. It's good to live in a small community because this is the kinds of things that happen. People show up and share their life with you, and I've been fortunate enough to have that happen. Friends like all of you here, I know, I recognize that it's because of you that my life has been blessed, and I am so fortunate to call each and every one of you a friend. So thank you for coming out. Please enjoy yourself. Please sign the ball, and thank you for keeping the surprise. I absolutely had no knowledge. Susan, thank you, my love. I appreciate it. Thank you, everybody. I appreciate it very much.
Hello. Welcome to rmproductions. Different start to our live tonight. That video will make a lot more sense in a little bit, but welcome everybody. I see pretty much everybody that we know and love in the chat. So tonight we are going to read a transcript. We're going to the theater, and we're going to be talking about the only other murder case that Nick McClelland has ever tried. So before we start, this always cracks me up. I want to start our live True Crime Theater. Hello, Sleuthy. I want to start our live talking a little bit about Willie Smith. Willie Smith. Oops. Get out of here, Nick McLeland. Okay. This is Willie Smith. He was a victim of homicide, unfortunately, but he is the victim in the case that we are going to be discussing this evening. So I think I can play.
Pride of New York right now.
Oh my
God.
That's AOC praising Monter Jones.
No
because
politics
Jones
in the chat.
supports her radical agenda. Defund the
Actually, I don't
police
care what
and
y'all
early
do.
release for
Who gives a
dangerous
fuck?
criminals. Jones supported it. He answers to AOC, not us.
Now at 11, a warning from a heartbroken family about the dangers of meeting people online. Thanks for joining us tonight. I'm Amanda Starantino.
And I'm Mark Mullins. A 22-year-old man and a 24-year-old woman are facing robbery and murder charges after Florida police say they contacted a Lafayette man through a dating app, then robbed and beat him to death. Tonight, WRTV's Amber Grigley shares a message from the victim's daughters.
I actually took Sade on a trip to Mexico for her graduation present.
What was supposed to be a week-long graduation celebration in Mexico was cut short for Jeanette and Sade Smith.
We got there on Tuesday evening, and Thursday morning, I received a phone call at around 4 in the morning, asking me my name and to confirm some information to prove that I know who Will is.
Their father, 55-year-old Willie Lee Smith Jr., was found unconscious on Wednesday on East Clem Street in Flora, according to the Florida Police Department. He was flown to IU Health, where he died on Friday.
I just automatically assumed, since he had kidney failure, that his kidneys failed again. So that's what I thought the call was about. But then she was like, he was attacked, he was hit in the head, someone needs to come.
As other family members rushed to Willie's side, Jeanette and Sade quickly learned that their father was on his deathbed. Police told Sade and Jeanette that Willie drove to Florida to meet a woman he had met on a dating app. Then investigators say he was robbed for $120 and beaten to death.
The story that I got from the police was that when he got out of the car to meet with the lady, that's when he was hit on the head with a bat and he laid in the driveway and stumbled into the neighbor's house and laid on their couch. Yeah.
I want the truth, and I want everybody involved to pay for what they did.
Jeanette and Sade remember the last time they saw their dad around Mother's Day. They say his bubbly spirit just brightened their day, not knowing that would be their last time.
I have an 8-year-old. Yeah, Will has a granddaughter who I can't even explain to her what's going on. It would be one thing to say, he was really, really sick and he, his body couldn't handle it anymore and he died. That's one thing, but to tell him I can't tell her this.
Now, Smith's daughters say that their father did not deserve this. And as they fight for justice, they hope by telling his story will help bring awareness to some of the dangers associated with online dating.
People are crazy. And you never know what someone is thinking or what their intentions are. So I still think people shouldn't. I know that we're in a pandemic right now. I know that things have changed right now, but I still believe in meeting people the old-fashioned way because you never know what people are up to.
Working for you, I'm Amber Grigley, WRTV. So tonight we're going to be talking about the homicide, the murder case associated with the homicide of Willie Smith, who was beloved. He had a big family in Indiana. He had daughters and grandchildren who loved him very much. And I know that we joke a lot on this channel, and we will continue to this even want to
go there before at least acknowledging and holding some space for the victim in this case, because Mr. Smith did nothing wrong. He did nothing wrong, and he didn't deserve what happened to him. And it's unfortunate that, as we'll talk about tonight, the trial and the case and getting justice for Willie and for his family has been convoluted because, as we know too well, Carroll County, Indiana is a hot mess. And the judicial system in Carroll County, Indiana is a hot fucking mess. So, without further ado, what we are going to talk about tonight is one of the individuals that was charged in Mr. Smith's death, named Jennifer Dean. Jennifer Dean was charged last. So 2 people were charged first. And then months after the homicide, a 3rd individual, Jennifer, was charged. And she was charged with felony murder. And it will become more clear as we continue. Oops. What I wanted to do, since we supposedly have a trial coming up in under a month in Indiana for the state versus Richard Allen, and the voir dire process. Hi, Charles Godwin. Will begin, jury selection will begin, and we figured, why don't we get a little insight as to what that might look like with the only other case that Nick McClellan has tried, the only other murder case. So we have some special guests with us this evening. First and foremost, we have the man himself, Nick Meow Leland. Hello, Mr. Prosecutor. How are you?
Hello.
Next up, we have the legend, shield me from this storm, you bloodlusty bloodlusters, Mr. Benjamin Diener, the Honorable. Hello.
Yeah, hello.
Okay. Next up, we have, I'm going to introduce Christine. Is going to be our many jurors, prospective jurors. Hello, Christine. Welcome.
Hello.
And some of you may know our beautiful, brilliant Oksana will be prospective jurors, et cetera, et cetera.
Hello.
Hello. Welcome. I don't know where Mr. Manahan is. We're going to give Mr. Manahan a minute or two to get here. But in the meantime, don't give up. We must remain silly. I'm going to say hi to some of our folks in the chat since we have a minute. So we have, of course, Kira is here. Hello, Kira. Sleuthy Goosey. Lead with Love. Fiend. Not to be confused with Mr. Prosecutor. Judge Jessica. Hi, Jessica. Hi, Jojo. Hello, KO, my dear, my love. Cleveland Rocks, as always, is here with us. Judy. Hi, Judy. Fiend, you got my wires all crossed. I guess our video was playing.
I'm sorry.
You're forgiven, Mr. Prosecutor. Hi, Barbie. T. Hello, T.
Judge Gall wasn't there to supervise me.
I know. Yeah. You were missing your prosecutor, your first chair. Hello, Catastrophe. Hello, Tiri. Nice to see you. The good Budette is here. Mar. Hi, Mar. True Crime Fangirl. Bum, bum, bum. Who did I miss? Pebbles is here. Hi, Pebbles. Jenny. 86753. I don't know why I know that song. I feel like it's a little bit.
I think everybody knows that song.
Yeah, I think you're right.
Yeah.
Hi, Linda Kay. Joe Schmo. Our friend Joe Schmo is here, as is beautiful Chelsea. Cleveland Rock says, did he? Did he had a bad day? Did he had a bad day? Hello, Heather Brown, my love. I hope I got everybody. Tammy, my girl. I think what we're going to do is I'm just going to read for Pat Manahan until Pat Manahan arrives. Pat Manahan is the defense attorney. Phil. Hi, Phil. Oh, yeah. Yeah, for sure. Post-punk mama. Dom. Miku's headphones. Oh my god, hi, All Eyes. Hello. Okay, let's do this thing, shall we? The royal wheat. Okay. So this transcript is super long because it's the entirety of a trial. We're going to start with the jury selection voir dire process, but the transcript in its entirety I will share after the fact because there's some really interesting charging hubbubaloo that occurs before the jury selection process where, well, we'll talk about that a little bit after, but all right, where is the transcript? Are we ready?
Sure.
We're ready.
Oh, it looks like our fearless defense attorney has arrived. Mr. Manahan is here. So I'm going to share my screen. I think Mr. Manahan is here.
You. That's right. I've manned more hands than you.
Okay. Looking good, Mr. Manahan. Okay. Here.
Your Honor, I just need, Your Honor, just 1 second. I dropped all my papers. They're on the ground everywhere. Nick, nope. I got it.
I
need your help with
dropped all my
everything, Nick.
papers too, Judge. We're gonna need a minute. The papers are all mixed together now.
You know what? This is perfect. You take whatever.
We'll just split
ex parte, not ex parte. We'll just pick it up.
We'll wing it.
Well, I have no other mode.
All right. Without further ado, I don't know. Can everyone see that? I will zoom in on it a little bit so we can. There we go. Oh my God, that's a little much. Okay. Take it away. The court. The honorable.
Thank you.
Yep.
You may be seated. This whole process is equally critical and superficial. So we want to know the information, and then it's up to the parties to figure out how much of the information they want to know. So don't ever share in the beginning, but feel free to share upon request. I'm going to ask you these questions. Some of the initial questions will be directed to all of you. If you find that your answer is yes to any of the questions, please raise your hand. I will then call upon you. We'll need to know your juror number if you wish, or your name for the record, some way that you can be identified. And then we'll ask you your answers to the questions. First question, do any of you know or are you related to either of the attorneys who are Patrick F. Manahan, Nicholas C. McClelland? Show of hands. We're seeing a paltry 3 hands so far. We'll start with the people in the box. Sir?
I know of Nick.
Okay, sir. Well, I'm sorry. Your juror name or number, your choice?
James.
Sorry. Back to the first guy. Your juror name or number?
Steve Pancake.
Thank you. And then, sir, the second one?
James Martin. And I know Nick.
All right.
Did you say James Martin? James Martin of Delphi High or James Martin of Carroll County Correctional Institution?
Mr. Manahan, you don't have any lines, sir.
Oh, okay. I thought I knew him. My bad.
All right, all right. It looks like in the second row, I think, a hand, yes?
McTeague. Both of the lawyers were in my dad's murder trial.
Thank you. And we're still seeing hands. I think front row, I see like, sorry, there's a glare behind you all as well. Gray sleeve, sir, it looks like.
Charles
Foreman. I went to school with Mr. McClellan, and basketball coach was the Mr. Mahanan.
Thank you. And I see a hand back there.
My mom worked with both.
And your name or number?
Glay Clausen.
Thank you. And then I thought I saw maybe some other hands. Yep, there's one, sir.
I know Nick and Pat both.
And your name and number?
Chad Peterson.
Thank you.
It's
Scanning back.
Mr. Manahan.
Scanning back, I see no other hands. Mr. Evans, if you would kind enough to put back that blind down more. I think it would help us to see some of the hands. I appreciate it. You have to lift up the bottom part first. Next question. Have any of the lawyers represented you, your family, or friends? We'll just assume it's to collect a pile of money. What? We don't need to know what for, but we need to know if they did represent you, your family, or friends. Okay? Okay? We see it, sir.
James Martin. Mr. Manahan represented me.
Okay.
A couple times.
Okay, thank you.
Mr. Manahan represented my husband.
Okay, and your juror number? Name or juror number?
My name is Beth.
Okay, I think I saw some other hands back here. I'm seeing a hand.
Hello there.
Samantha Feltner. Mr. McClellan was my ex-husband's lawyer.
Thank you.
Mm-hmm.
Samantha Feltner, her husband?
Mr. Feltner?
Samantha Feltner.
Okay.
She said her husband was affiliated with you in some capacity.
Thank you, Judge.
Try to speak up. It does seem like I'm being obnoxious. It's in part because I am. But it's also so that you guys can hear. So we also need to be able to hear you. It's being recorded and preserved for posterity. So those are the last of other hands I'm seeing. Next question. Do any of you know or are related to the defendant, Jennifer L. Dean? I'm seeing one, a couple hands maybe, front row.
Yes, I've known her uncle and her for 50 plus years, and I've worked with her uncle for 39.
Thank you. And your name or juror number?
Bill McCarty, William McCarty.
Thank you, sir. And then I saw another hand back there.
Bradley Martin. She's a customer of mine on my route.
Okay, seeing no further hands. Next question. Do any of you know or are related to the defendant's family? Seeing no further hands. Did you know the victim, Willie Smith Jr.? Seeing no hands. In a moment, I will list potential witnesses one at a time. If you're related to or know any of the potential witnesses, please raise your hand. Joshua Barnes, I see a hand in the front row. Sir?
Yeah, William McCarty, and I also work with his father. I know Joshua.
Okay, thank you. Seeing no further hands. Sarah Barnes? Seeing no hands. Cassie Lane? I see a hand. Front row, sir? Sir?
Works for
Potentially. Cassie Lane.
Yeah, I know Cassie Lane.
Okay, and your name or juror number, sir?
Charles.
Oh, go ahead, Christine.
Charles Foreman.
Thank you. Seeing a hand back here.
Valerie McTeague. I went to school with Miss Cassie Lane, I believe.
Thank you. Miss?
Karen Dinger. Not really, no, but I have talked to her on the phone a couple times.
Okay, seeing no further hands. James Bishop? Miss?
Karen Dinger. He's a part-time officer for the town of Burlington.
And that's how you know him?
Mm-hmm.
Okay, front row.
Charles Foreman, firefighter with him for years, and then I'm also the fire chief, so I've communicated with him quite often.
Thank you. And I saw another, sir?
William McCarty. I work for the town of Flora, and he is our chief of police, and I deal with him on a frequent basis.
Thank you. Seeing no further hands. Paul Redman? Miss?
Karen Dinger. Known him personally and through the town of Flores police chief.
Thank you. And behind you, sir?
Steve Pancake. I know him personally.
Thank you. And Miss?
Morgan Hayden, family friend, and I clean their house.
Thank you. Sir?
Kurt Jenkins. Just knew him as a police officer there in Flora.
All right. And a hand back there?
Abigail Burns. Oh, shoot. Knew him as a police officer in Flora.
I didn't get your name or number, miss.
I apologize. Abigail Burns.
Thank you. Sir?
Peyton DeVos. I guess I know him personally, and he's a police officer in Flora.
Thank you. Miss, I think I see a hand back there. One other disclosure. I can't see anything. So that's just a me issue. It's kind of fun, though, to see the movement. What?
Judging
Miss?
by your legal decisions, that's not surprising, sir.
Miss?
Kelly Best. Personal friend.
Okay, seeing some more hands. Front row.
Pam Spangler. I know him as a police officer.
Okay, thank you. And then behind you in the black jacket.
Chad Peterson. I've known him. I used to hang out with him some years ago.
Thank you. Sir, front row.
Charles Foreman. I know him personally, and I worked incidents with him as a police officer.
Okay, and then beside you, sir.
William McCarty, again, Chief of Police of Flora, my employment.
Thank you. And behind you, I think I see a hand. Sir?
Bradley Martin. I know him for several years.
Thank you. And then behind you is another one.
Braden Moat. A family friend, and I know him personally as well.
Thank you. Next person, Steve Mullen. Miss?
I went to school with his daughters, so...
And your name or juror number?
Oh, sorry. Christy Nice.
Okay. Miss?
Karen Dinger. Steve spoke with us regarding an incident within our family.
And sir?
I've known him as a police officer.
And I'm scanning. I think I see a hand there.
Jessica?
Well, two hands right beside. Yep.
Jessica Kilty. I know him through a relation and a police officer.
And then beside you is a hand.
Valerie McTeague, as a police officer.
Thank you. And then right there in the back, it looks like.
David Walters. I'm a friend of Brian's family.
Okay. And then in the back.
Kelly Best, family friend.
And in the front.
I've just known him as a police officer in the family.
Thank you. And then we're back in the front row again. Sir?
Charles Foreman. I know him personally, and I've worked incidents with him in the past.
And beside you?
William McCarty. We've chatted on the in the office every once in a while.
And then behind you in the...
Brian Northrop. I've known him as a police officer from Camden.
And then behind?
Glegg Clausen. He's a family friend.
I think that's the hands I presently see. Mark Thomas. Got some hands over here, front row. Sir?
There's one more over here. My name is Marcus McGillicuddy. I used to give him wedgies and throw him into trash cans in high school.
William McCarty, same thing. He's a police officer for the town of Flora, and I see him on a regular basis.
And beside you, sir?
Charles Foreman, same thing. I've known him as a police officer, worked with him.
Thank you. And then I'm seeing a hand back there.
I just know him as a police officer, Taylor Leahy.
Taylor Leahy. Seeing no other hands. Mike Thomas. Seeing more hands over here. Sir?
Through my daughter, to his daughter, and my daughter are friends.
And your name or number?
Steve Pancake, sorry.
That's all right. And then I'll scan this way. I'm seeing a hand right there.
Valerie McTeague as a police officer.
Okay, and in the back?
Taylor Leahy. I know him as a police officer.
Okay, and then in the front?
Charles Foreman. I've worked with him, incidents with him.
Okay, and to your left?
William McCarty, same thing. I see him in our office quite often.
Now, it's such a bizarre reference, but if you've ever seen The Muppet Show, with you two sitting by each other, I feel like we're having a dialogue. And I feel like you guys are just up here talking about the show.
We're going to work with each other.
All right, but I'll leave my own observations out of it. I apologize. The next person, Lori Sostarsik. See, I do a couple of hands over here. Black jacket, sir?
Chad Peterson. She was good friends with my sister in high school.
Okay. And back there?
Glay Clausen. I work for her at the jail.
Thank you. Seeing no further hands. The next name, Ashley Luther. Seeing no hands. Apologies up front to all the names that have been mispronounced or will be mispronounced during the proceedings. Christopher Polos. Seeing no hands. Tyrone Lethbridge. Seeing no hands. Cheyenne Brooks Brown. Seeing one hand.
Valerie McTeague. I believe she worked for an organization that I worked for in the past.
Seeing no further hands. Melinda Crane. Seeing no hands. Kayla Clement. Seeing no hands. Matthew Troyer. Sir?
David Walters. He's a coworker.
Okay. Oh, sir?
James Martin. I worked a job years ago when he was a helper there.
Seeing no further hands. Molly Todd. Seeing no hands. Melinda Train. Seeing no hands. Corey Dean. Seeing no hands. Jocelyn Tillis. Seeing no hands. Justin Sieber. Seeing a couple hands over here. Miss?
Deborah Parsley. He's my neighbor.
Okay, sir.
I've known him for years back as through acquaintances.
And your name or number?
James Martin.
Thank you. And then I thought maybe there were more. There's a hand there.
Bradley Martin. I went to school with him and have known him for years.
Thank you. Seeing no further hands. Cheyenne Mann. Miss?
Karen Dinger. I know him through the dark web. I mean, his dad.
Seeing no further hands. Bo Dornbus? Seeing no hands. Miranda Gillerin? Seeing no hands. We've not discussed what it is, but based on the information you've heard so far, without stating what it may be, do any of you have any personal knowledge of the facts of this case? Seeing no hands. Have any of you read or heard anything about this case? Seeing no hands.
Your Honor, there's one over here.
Ah, thank you. We've got a brown sleeve next to a brown banner in the back. That's my excuse.
Tina Scott. I believe I read about this, that it happened in Flora.
Well, let's not talk about what you think you've read or what you may have read, but that may be discussed between the parties and you in private at some juncture. Thank you for that information. Seeing other hands. Continuing on with the questions. Does anyone have problems with their vision, such that it will be difficult to view exhibits or observe witnesses as they testify? We're in the arena where it will be occurring. This is the main witness seat. That's primarily where the jury will be sitting. This area will be used from time to time, perhaps with screens, etc. And so those are the approximate distances you may have to see. You may be provided with papers to look at from time to time or pictures to review in silence. But as ornate and beautiful as this courtroom is, and as much as a privilege it is to work here, you can note that it is lit by natural light a lot of the time. And so that may fluctuate, and that can materially affect one's ability to see things. And so, does that affect any of you, your sight, such that you can, we're seeing one hand. Miss?
Valerie McTeague. I have diabetic retinopathy in my eyes, so it's hard for me to see very well.
Thank you. Is anyone here not a citizen of the United States? I'll just ask you to leave. You can't participate in the trial. It's anyone here. I didn't see any hands on that, by the way.
Put your hands up if you're committing a felony right now. Liggett will beat you in the alleyway.
Is anyone here not at least 18 years of age? See no hands. Is anyone here not a resident of Carroll County? Seeing no hands. Is anyone here not able to read, speak, or understand the English language? Perhaps the second language or third language? Seeing no hands. Is anyone here suffering from a physical or mental disability that prevents you from rendering satisfactory jury service? This is not a question to pry into your personal medical conditions. Reasonable accommodation will be made for anybody wishing to serve that has a condition. However, if you have a condition that makes it unreasonable for you to wish to participate and you wish to be excused, we may need to know about that in public or private if you would request a private session. If you have a medical condition that makes it difficult or impossible for you to serve. All right, we're seeing one hand. Do you wish to respond in public or private?
Public is fine.
All right.
My name's Brian Northrup, and I've been diagnosed as a traumatic brain injury from a car wreck, so it does affect my short-term memory and I have headaches.
And because of that, you don't wish to serve?
I'm just letting you guys know.
Okay. As this is unfamiliar to most of you, the general consensus from the parties, meaning the state of Indiana and the defense, are you are all great. They would love to have any of you. If you're able to serve and willing to serve, they think you'll do a good job. And so, if this condition affects your ability and you want to serve, you may get a pass out. But if you want to serve and we can allow that with reasonable accommodations or no accommodations, we're not going to prohibit you from serving. You understand that?
Yes.
All right. Well, he's answered the question. And then we've got, I think I saw another hand somewhere. Do you wish?
I don't think it's a medical condition.
Oh, well, just we'll get to it later. There's a catch-all later about.
Okay.
If your mind's elsewhere, they'll really drill down on that later. This is just, we could skip all of this. So it's mandatory, so we got to do it. Sorry. We'll get to the important stuff later. Getting to more important mandatory things. Is anyone here under guardianship appointment because of a mental incapacity? Seeing no hands. Is anyone here a person who has had rights to vote revoked by reason of a felony conviction and whose rights to vote have not been restored? This is not a function in Indiana law. You would have to be subject to some other law. See no hands. Is anyone here a law enforcement officer? Are you a cop? See no hands. All right, we've got to be near the end of these. Oh, there's a couple more questions. Nope, it'll get better before it gets worse, I promise.
What?
The Constitution guarantees a right to trial by jury. I'm now going to discuss with you certain other constitutional or legal principles. Under the law of this state, a person charged with a crime is presumed to be innocent. Really? To overcome that presumption of innocence, the state must prove the defendant guilty of each essential element of the crime charged beyond reasonable doubt. The defendant is not required to present any evidence to prove his or her innocence or to prove to prove or explain anything. Do any of you disagree that the defendant is presumed innocent as he or she sits here today? Seeing no hands. Do any of you sitting here now believe that because the defendant was arrested and charged, then he or she must be guilty? Seeing no hands. Do any of you disagree with the principle that do any of you disagree with the principle that a defendant has no obligation to do anything during the trial to maintain his or her innocence? Seeing no hands. The state must prove each element of the crime charged beyond a reasonable doubt in order to overcome the presumption of innocence. You will be instructed that, under the law of the state, proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you're firmly convinced that the defendant is guilty of the crime charged, you may find him or her guilty. If, on the other hand, you think there is a real possibility that the defendant is not guilty, you should give the defendant the benefit of the doubt and find the defendant not guilty. Do any of you disagree with the principle that it is the burden of the state of Indiana to prove the guilt of the defendant beyond a reasonable doubt? Seeing no hands. The defendant in a criminal case has a right not to testify on his or her own behalf. If the defendant in this case does not testify in her own behalf, you cannot hold that fact against her. You cannot discuss her failure to testify, refer to it, or in any manner consider that fact in determining the guilt or innocence of the defendant. Do any of you disagree with the principle that a defendant has the right to remain silent and that the defendant need not testify? Seeing no hands. Is there anyone who would be unable to follow the court's instruction to not discuss or consider a defendant's decision not to testify? Seeing no hands. Do any of you feel that you tend to be biased for or against the state of Indiana?
Yeah, I'm for. Oh, sorry.
For or against the defendant in this or any other criminal case? And we'll hear more about that later. Seeing no hands for now. Do any of you have any biases or prejudices against certain groups of persons related to race, religion, sex, lifestyle, or looks? Seeing no hands. Is there any reason not covered by one of my questions that you could be unable to listen with an unbiased mind to the evidence in this case and reach a fair and impartial decision? Seeing no hands. We'll experience, if you're not from Delphi City proper, a staggering amount of trains during the trial, and we'll do our best to still hear evidence, but there may be times that we have to take breaks altogether if the trains are too noisy. So be prepared for that. You'll know when it's happening. Both attorneys and the court have a copy of your jury questionnaires. The attorneys are now going to ask you some questions about your answers to the questions, as well as other matters they deem relevant. As I mentioned previously, no one is trying to pry or be personal. The only concern is that a fair and impartial jury be chosen. After the lawyers question the first 12 people seated in the jury box, they will exercise their challenges, and we will seat additional jurors as may be necessary. We will continue in this matter until we have selected all necessary jurors. For those jurors in the audience, I would encourage you to listen to the lawyers' questions, as it will give you an idea of what to expect if you are seated in the jury box. And the process will move more quickly if the lawyers don't have to repeat all of their questions when a new juror is seated. The objective today, Monday, is to get a jury selected. It's 2:25 p.m. That's our objective. We'll turn the floor over to the state of Indiana and the defense counsel for continued voir dire examination and prospective strikes, beginning with the state of Indiana through the elected prosecuting attorney, Nicholas C. McLeland. The floor is yours.
Thank you, Judge. Mr. Manahan, ladies and gentlemen, good afternoon. I'm glad we've gotten to this point and that you're all here. As the judge said, it's kind of been a long time coming to try to get this case tried, and so I'm glad we've made it to this point and made some progress forward. And I'm going to be really honest, I'm a little nervous. It's been a long time since we've had a jury trial, and on top of that, this is a murder case. This is as high as it gets in Indiana, right? We don't have a charge higher than this, and so I'm a little nervous to be here. Anybody else nervous? Nobody at all? But I want to make sure I got the names right first, because we kind of switched people around. Mr. Appleton, is that right?
Yes.
You nervous to be here?
Yeah, first time doing this whole process.
Being on a jury?
Mm-hmm.
Anybody else? Everybody? Good. It's okay.
First time.
Okay, good. Now I want to make sure I got the names right. Joyce Peters.
Yes.
Right?
Oops.
Deborah Parsley, is that right?
Mm-hmm.
Kylie Moore.
Yes.
Karen Dinger. William Timko. I see another Mr. Appleton.
Yes, sir.
Morgan Hayden.
Yes.
James Martin. I know you. Kim Klingenpeel. Is that right? Okay. Mr. Pancake. I know you. Beth Burkhart. Is that right?
Yes.
And then Christy Nice. Is that right?
Yes.
Okay. So it's okay to be nervous. We're going to get through it together. All right? I want to start off, and I always start off the same way, talking about being honest with one another. As the judge said, these questions aren't to pry or to get involved in your personal life, but we need you to be honest with us to make sure that you're a right juror for this case. You're all good jurors on certain cases. This just may not be the one. So I always start off, can somebody give me a definition of what it means to be brutally honest? Mr. Appleton, let's start with you. Can you give me a definition of what it means to be brutally honest?
Completely honest and no doubt in your mind that there could be a lie in your head.
Okay. Mr. Timko, what about you? What's it mean to be brutally honest?
Able to look somebody in the eye and tell them the truth.
What if they don't agree with that truth?
Then they're good at it.
Miss Moore, you raised your hand. What do you think it means to be brutally honest?
To speak the truth regardless of being not caring if you're going to offend anybody, because that's the truth.
Does anybody have anything different than that?
Having integrity.
Having integrity? Okay. Can we come to a consensus today that brutally honest is that you're going to be honest with me regardless if it's good, bad, or indifferent, regardless if I like it or not? You're just going to be completely honest with me. Can we agree that that's what we're going to do today? Okay. I see everybody shaking their heads, so I'm going to move on. So as the judge said, this is jury selection. This is where Mr. Manahan and myself, we ask you questions to get to know you better, to make sure that you're a good juror for this trial. You're all good jurors. You just may not be a good juror for this trial. So what we have here, we have 2 counts here that we're trying today, or going to attempt to try today. One is murder, and one is conspiracy to commit robbery, resulting in serious bodily injury. So, Miss Nice, when I say there's the charge of murder, what do you think of?
There's a murder in this. I don't know if you can hear me. I have an ear infection, so I don't know.
Okay.
If I'm talking loud enough.
Well, if you think you're talking loud, you're probably not.
Okay.
This room is huge.
Okay.
And it's hard.
Right.
Really hard to hear people because it's not very good at acoustics. So as loud as you can talk.
Okay.
We'll all appreciate it.
So when I think of murder as someone's killing somebody on purpose or on accident, it just depends on what the case is.
Okay.
Time.
All right. Miss Cleanpeel, what about you? What do you think of when you hear murder?
Someone killing somebody.
Okay. Mr. Martin, what about you?
Could you repeat the question?
What do you think about when you hear the charge murder? What do you think?
Well, somebody evidently killed somebody, and they've got to go through the motions to see whether they actually did it or not.
Okay, there's actually some different kinds of murder in Indiana. The murder we're here to talk about today is murder that occurs in the process of someone committing a felony, okay? So what it says is, let me look this up. When someone commits arson, burglary, child molesting, kidnapping, rape, human trafficking, and robbery, and someone dies in the course of that felony, and it doesn't matter if the death was intentional or accidental, a murder was committed. Does everybody understand that? Okay. Commonly referred to as, let me look this up, felony murder. That's how we refer to it. In the process of committing a felony, someone
Wait,
dies.
did you say the charge was felony murder?
Let me check that again. Felony murder.
That's what I had. Oh, okay.
That's how we refer to it. In the process of committing a felony, someone dies,
Okay.
whether it's intentional or unintentional. In the state of Indiana, that is murder. All right? I do really well with examples. And so we're going to go through an example. All right? Let's do Miss Hayden, you, myself, Colton Appleton, and William Timko. We're all friends. And we all decide that we're going to rob a bank together, okay? And let's say I'm the guy that's going to go into the bank and talk to the teller and rob the bank, okay? You're going to be the getaway driver. Mr. Timko, you're going to be the lookout down the street. Make sure no cops are coming. Mr. Appleton, You're going to be the one at home, but you're going to help plan for us. You're going to help us plan it. Get us the supplies, help plan it, split the money that we get afterwards. Fair enough? All right. Miss Hayden, you drive me to the bank. I go in. Things go really wrong, and I shoot one of the tellers. I run out, get in the getaway car. You drive down. You pick up Mr. Timko. We go back to our hideout. We split the money amongst ourselves, and we try to get away, and we get caught. Mr. Timko, is he guilty of murder?
He'd be an accomplice, he is.
But he was just a lookout down the street. He didn't go in the bank.
So he was part of the plan.
Part of the plan.
An accomplice.
What about Mr. Appleton?
Same. We're all having troubles.
In for a penny, in for a pound. Does everybody know that saying? If you're in for a little bit, you're in for all of it. Is everybody comfortable saying it? It's sometimes hard for jurors to find the lookout or the getaway driver or the person that helped plan it as culpable as the person that pulled the trigger. Does anybody have any questions about that? That's the law in the state of Indiana. If you aid, induce, or cause and work with other people to commit a felony and someone dies, whether intentionally or unintentionally, everyone involved in that group is guilty of murder. Fair?
Mm-hmm.
Okay, next charge. Conspiracy to commit robbery resulting in serious bodily injury. Miss Dinger, what do you think of when you hear that?
It's a mouthful.
It is.
And can you say it slower?
Sure.
It's too fast.
Conspiracy to commit robbery resulting in serious bodily injury. It is a mouthful.
So I guess I would think of it in the same vein of what you said the murder was, is you conspired to commit a robbery and then something else happens.
And the result is somebody gets hurt.
Mm-hmm.
That results in serious bodily injury.
Yep.
Mr. Pancake, what? Am I saying that right?
Pancake.
Pancake. What do you think about when you hear that?
Sounds to me like a plot that if it wasn't self-defense, then it's still murder.
Okay. Now, as you can kind of tell, we're talking, and the judge just kind of went over this. We're talking about allegations that occurred, and these occurred back on June 15th. Between June 15th and June 21st in Flora, Indiana, near 115 East Clem Street. There was one juror, prospective juror, said that she may have read about it. Has anybody else heard about this? Okay, let's start off with Miss Parsley. Your home address is close.
Yes, it is.
To where the allegations said this occurred.
Yes, it is.
Were you home? Do you know about this? Tell me what you know about this case.
I wasn't home at the time, or yes, I was at home, but yes, I was at home at the time. I was asleep at the time. I don't know how much you want me to say.
Well, do you know anything about the case right now?
I know about the case right now.
Were you interviewed by law enforcement?
No, I was not.
Okay. Did you talk to anybody that was interviewed by law enforcement?
No, I was not.
Okay. Have you talked to anybody, any of the witnesses that the judge went over, or Miss Dean, about what happened on that night?
My husband has talked to Justin.
Justin Siebert.
Yes.
Okay.
I have not.
Okay. Did your husband then talk to you and tell you what he had heard from Mr. Siebert?
He told me a little bit. Him and Justin are real close.
Okay.
I'm just there.
Fair enough. Well, this is
Same.
You have to tell us. We don't know. We're only going by what you tell us. You feel that you've heard enough about the case where you wouldn't be comfortable being a juror on this jury? Answer that question first. Do you feel that you've heard enough about this case where you don't think you'd be a good juror for this case?
No, I don't. I think I would be a good juror.
Okay. Have you heard enough information where you've already formed an opinion of Miss Dean's guilt or innocence?
No, because I didn't know the exact people. I just know of the incident. I don't know of the people that were involved in it.
Okay. If as time goes on and we start to ask more questions and you hear more, I guess, statements from us and other people, if you feel that you know too much, will you let us know?
Yes, sir.
Okay, all right. And then Miss Dinger?
I'm not 100% sure, but I read the newspaper a lot, and I'm pretty sure I saw something in the newspaper regarding this case.
Okay.
Mm-hmm.
Do you have information that has caused you to form an opinion about Miss Dean's guilt or innocence at this point?
I'm not 100% sure I'm remembering the exact case. I just remember reading something about it. And if that is the one I'm thinking of, then there might be an opinion.
Okay.
But I'm not going to know until we get going.
Sure. As we go on, if you feel that, well, let me ask you this. Do you feel comfortable knowing what you know so far? Would you feel comfortable being a juror on this case?
I would treat it with what it needs to be treated with.
Okay. Okay. Again, in the future or as we go on, if you hear more stuff, let us know if you feel uncomfortable or, hey, I know about that. Actually talk to some people about it. Let us know.
Sure. Mm-hmm.
Okay. All right.
1 second, Mr. McClelland.
Sure.
It'd be worth noting that the publication referenced is for for-profit publication, that the veracity of the contents is subject to the person reading it. Newspapers can print untrue things knowingly in certain cases, or sometimes they may just unintentionally print untrue things. But she's read some things on the paper apparently, so that's where we are about that. It gets murky pretty quick. So you have your own individual viewpoint of how you treat the news and you read the paper, whether it's entertainment or informative or something else. But sorry for the interruption, Mr. McClelland. We only have one paper in Carroll County for the Court of Appeals, just so that they know.
Thank you, Judge.
Excuse me?
What?
Yes, Mr.
Manhan.
Right?
Can we pause for a second?
Yeah, please. What?
Can we take a time out? What do we think about that? Can you read it again, Your Honor? Can you read that part again?
It'd be worth noting that the publication referenced is as a for-profit publication, that the veracity of the contents is subject to the person reading it. Newspapers can print untrue things knowingly in certain cases, or sometimes they may just unintentionally print untrue things. But she's read some things in the paper apparently, so that's where we are about that. It gets murky pretty quick. So you have your own individual viewpoint of how you treat the news you read in the paper, whether it's entertainment or informative or something else. But sorry for the interruption. We only have one paper in Carroll County for the Court of Appeals, just so they know.
Why are we talking to the Court of Appeals? Does it?
Benny knows where this
Travis-
is going.
Travis says, "What the fuck is this? This has nothing to do with the standard for removing a potential juror for cause." Right.
I just know if
removing
if
cause
Diener
you
asks
want
if
to.
you're a cop, you've got to tell him because that's the law. Are you a cop? You've got to tell us.
He's
I know that.
He's like, we have one paper in Carroll County. Sometimes the paper prints untrue things, and just so the Court of Appeals knows, it's a for-profit paper. I want to just repeat what Travis said. What the fuck is this?
Oh my God.
Go ahead, DB.
Well, I was going to say that before I was interrupted, I was going to say that he said it was a for-profit paper. And why is he talking to the appeals court? And what the fuck is this? This has nothing to do with the standard for removing a potential juror.
I
All
think
great
Judge
questions.
Diener just likes to hear himself talk.
I think you're right, Christine. Well,
I like the part that it gets murky pretty quick. I'd like to.
Yeah, what are you, an expert on investigative journalism, sir, and the non-profit profit status of companies who publish newsworthy articles? What the fuck is he talking about?
I don't know, but we only have one paper in Carroll County, just so the Court of Appeals knows.
They've been looking at me. They've been hounding me. So I'm going to
Court
talk
of
right
Appeals
into
been
that.
on my ass. So, okay. Are we ready to proceed?
Yes, I see the banner is down, and we are back to regular legal takes.
Excellent, Mr. McFeelan.
Thank you, Judge. Now, with those charges, we've talked about what they are. We've talked about whether or not you've heard about them. I want to start with the murder and how I explain that. Miss Hayden, what kind of evidence would you expect to see in that type of charge? What kind of evidence would you expect the state to put on? It's a murder. It's a murder charge. What kind of evidence do you expect to see?
Well, some type of planning.
Okay.
Evidence, fingerprints.
Okay.
We have DNA that she was at the scene. What do they call it? Motive.
Okay. Miss Nice, what about you?
I was thinking the same. What she said, planning, and then why would they want to do what they did?
Did I mention I was nervous? Okay, Mr. Simcoe.
At least a murder weapon.
Shit. Okay. Anything else you can think of?
Fingerprints on it.
Okay. Miss Moore?
Some photos.
Okay. All right.
And then I feel like I had to keep.
How many people have seen CSI, or at least something like that?
Yeah.
Okay. All right. Anybody have anything different? All right.
I mean,
go ahead. Yeah, Miss Dinger.
Communication.
Okay.
Text messages. Blah, blah, blah.
Okay. That's good. Anybody else have anything else they can think of? Like anything you can think of. What about the...
Maybe like admittance, like guilt.
Okay. Like kind of admission from some...
Yeah.
Somebody.
Mm-hmm.
What about the conspiracy to commit robbery?
Planning.
Miss Klingenpeel, what about you? I haven't heard much from you. What kind of evidence would you expect to see?
An eyewitness?
Okay, all right. Miss Moore?
Text messages, social media conversations, things like that.
We all have our phones now, right?
Yes.
Does everybody have their phone on?
Mm-hmm.
Don't leave home without it, right? So we all have our phones. Now with the evidence, there's various kinds of evidence, right? There's different kinds of evidence. We talked about text messages, we talked about DNA, we talked about admissions. Well, there's also a form of evidence called circumstantial evidence. I'm going to read you the formal definition of that, and then we're going to talk about it.
It's the strongest evidence ever. It's the best evidence.
Circumstantial evidence is evidence that relies on an inference to connect a fact to a conclusion. So I'm going to give you an example. I'm really happy it snowed last night because I always use the same example. And when it snows, it helps the example kind of ring true to home. So Miss Moore, I'll pick on you. Spring break was not too long ago. Let's say when you leave for spring break, the yard is dry. The house is fine. You go to spring break for a week and you come back from spring break and there's a giant puddle in your front yard. What happened?
It rained. It snowed.
But do you know?
No, I don't know because I wasn't there.
Okay.
No, the only thing,
Okay, you go to spring break, you come back, there's a big puddle in the yard, and there's 2 sticks in the puddle. Do you know what happened?
Yeah.
Now, what if
A
the
ritual.
sticks are formed in a rune shape? Okay, you come back from the spring break, there's a big puddle in the yard, 2 sticks and a carrot. Do you know what happened?
Yeah, the snowman melted.
Okay, firmly convinced?
Kind of. I mean, yeah.
Okay, all right. So
If there was there a snowman there?
no, there was no.
And I've been gone.
When you left for spring break, the yard was empty. It was dry. You went on spring break. You come back. There's a big puddle in the front yard, 2 sticks, and a carrot in that puddle.
I have no idea.
No idea? Come back from spring break, 2 sticks, a carrot, and a scarf.
Wait, I'm starting to still believe it's a snowman because...
Firmly convinced?
No, because I didn't see a snowman there before.
Okay, come back, puddle, 2 sticks, a carrot, a scarf, and a top hat.
The snowman.
Somebody was trespassing.
Yeah,
Somebody was trespassing on your property.
Firmly convinced?
I mean, if there was no snowman there before, but then all the stuff for a snowman was there, I would think.
You're making an assumption.
Okay, I'm sorry, real quick. This man said examples were his thing.
Oh my god. What? Can we reread that?
Wait, where?
Can we reread that?
He was, but yes, I would make my assumption that there was a snowman that melted.
2 sticks, a carrot, a scarf, a top hat, a name tag that says Frosty. Now you firmly convinced?
Okay, fine, yeah.
Okay, we talked about firmly convinced because that is what it takes to prove the element of each offense beyond a reasonable doubt. The burden is on the state to prove each one of those counts, the murder and the conspiracy to commit robbery, and we have to prove each one of those elements beyond a reasonable doubt.
Okay.
What does that mean? Firmly convinced. I use that example and talk about circumstantial evidence because you didn't see the snowman being built. You didn't see it melt. You didn't see what happened, but you were told certain things, certain inferences that can lead you to a conclusion and can lead at some point to a conclusion where you're firmly convinced, right? So you've got to decide at which point in the example that I gave you are you firmly convinced. Now, the burden on the state is beyond a reasonable doubt. It's not beyond all doubt. The judge is going to read instructions, and we've heard, as myself and Mr. Manahan have heard him several times, to be firmly convinced beyond all doubt is nearly impossible. If you have a video of a snowman being built and a video of the snowman melting, that would be beyond all doubt, right?
Yes.
No question in your mind. You saw it built, you saw it melt. You know what happened. Very rarely are we convinced beyond all doubt. And that is not the burden for the state. It is beyond a reasonable doubt. Firmly convinced. Okay? And again, the state has to prove each element of each offense beyond a reasonable doubt. And the judge is going to go over each one of those elements and what they mean. And we've talked a little bit about the murder count. We've talked about that. The robbery count, and we've talked about that. So the state's going to put on evidence through testimony, through physical evidence, to try to convince you beyond a reasonable doubt each and one of those elements. And so is everybody comfortable with the idea that beyond a reasonable doubt is firmly convinced and not beyond all doubt? Miss Hayden, yes?
Yes.
Mr. Martin?
Yep.
Miss Klingenpeel? Okay. Anybody else have any questions? Okay, another example. I always use this example, and I like it. Somebody I don't know. Let's see. Miss Burkhart, do you believe I'm an attorney?
I know you're an attorney.
Okay. How do you know that?
People talk a lot, but I don't try to listen to all that talk and that.
Okay.
But no, I believe you are.
Okay. All right.
I heard you're the best attorney. Him.
Hey, I appreciate that. I like that.
I think the question was attorney, not a word, but
Yeah. Miss Peters, what about you?
You're hearing this. You're hearing this court, so you must be.
Okay, but you haven't seen my ID.
No, I do not know you.
You haven't seen my law degree. You haven't seen...
I haven't heard anything about you.
You haven't seen anything about me, but do you believe I'm an attorney?
Yes.
Firmly convinced?
Yes.
Beyond a reasonable doubt.
Well, based on your behavior in the Richard Allen case, I'd have to say no. Yes. Maybe.
Yeah, I understand. Makes sense. The judge probably wouldn't let me practice in front of you if I wasn't an attorney. The state of Indiana wouldn't let me represent them if I wasn't an attorney. Fair?
Yeah.
The point is, there can be varying degrees of evidence to convince you beyond a reasonable doubt. It can be very little. It can be a lot. It can be circumstantial. It's up to you to decide when you're firmly convinced. But again, beyond all doubt, would you see my ID, my bar card, my diploma, my license, all those things, right?
We wouldn't need all of them, just one, but yes.
But that would be beyond
Yes.
all doubt.
Sir, that's called an investigation.
That would be beyond all doubt. This is not the burden for the state. Now, is there anybody that thinks that burden is too low? Is there anybody that thinks that burden is too high? Is there anybody that thinks the burden is impossible for the state to meet? We've run into people on occasion that say, look, unless you can prove to me beyond all doubt, I'm not going to find a person guilty. And it's okay to have that opinion. Is anybody of that opinion? I have to see with my own eyes to believe it happened. Okay, I've kind of beat that dead horse, but I want to make sure. It's kind of like, it's a varying concept for each person, and it's kind of hard to understand. So I want to make sure everybody understands that. Is there any questions? Okay. Now, one of the ways where the state is going to prove those elements of each offense is through witness testimony. And so I want to talk about when you look for when someone testifies. So, Mr. Pancake, I'm going to say that wrong every time.
Very good.
One more time. Say it for me.
Steve Pancake.
Pancake. Okay. Mr. Pancake, what kind of things do you look for to determine the credibility of someone that's a witness?
Where they stand with society, what their job is.
Okay.
Where they fit in with the public.
Okay.
Have they been in trouble with the law before?
Okay.
A lot of different aspects of things.
Okay. And so, would you give someone more credibility simply because of the job they work in, say, law enforcement officer?
I would like to, but I never fully know. You never fully know.
Sure.
Who is who?
Sure. Would you give somebody less credibility because of where they work?
No.
Okay. You had mentioned if they have a prior criminal conviction. Would you give them less credibility if you knew they had a prior criminal conviction?
For me personally, it would play a part on my thought process.
Okay.
I would have to have some evidence, I guess, or some proposals to know that they're doing better in life.
Okay.
Before I would think that they're totally rehabilitated.
Okay. Can you think of any scenario where you would give somebody more or less credibility simply because of where they work or what they've done?
A good one would be, I'm going to use myself as example. There's a couple people out there. There's a young man that's out here in the chairs, and I coached wrestling for 12 years. Had a lot of people, not that I'm a bad guy, but a lot of people automatically assume that I'm a great guy because I worked with their kids. So they don't know. No one knows the true deep secrets about me, you, the judge, or anybody.
Okay.
Mr. Mullen, can we get a Celebrite extraction from that gentleman? No, that's the one with the cell phones. Yep.
The Mr.
The
Pancake. Sure.
They don't know my past, where I've came from. I don't care what the security clearance check
Sure.
was.
Sure. Miss Dinger, what about you? Anybody that would you give someone more credibility simply because of where they work or what they do for a living?
In my opinion, police officers.
You would give them more credibility?
More credibility, yes.
Simply because they're police officers?
Yes.
Would you give somebody less credibility because of where they work?
Not where they work. If there was a prior conviction, that might weigh on my mind.
Okay. What kind of things are you going to look for to determine whether or not someone is being truthful or not when they're testifying?
Obviously, they've taken an oath, so you hope that they, take the oath under serious consideration and follow that. But I would say, body language and just be watching them and see what their responses are.
Sure.
As they're being asked questions.
Eye contact?
Mm-hmm.
That'd be one. Body language?
Eye contact.
What about if they're nervous or not? Would that play into anybody's opinion on whether or not they're telling the truth?
Absolutely.
Okay.
I think they'd all be nervous.
Mm-hmm.
It's a fair point. Fair point. Has anybody testified in a trial before?
Has anyone tried a murder trial before?
I know I haven't. I've always been on the other side, right? So I've never testified. I assume it's pretty nervous just to be in the seat, being grilled from each side with questions regardless of what it's about. What about a preacher? A preacher got up here and testified. Would you give him or her more credibility simply because of what they did? Miss Hayden, you're shaking your head no.
Nah.
Okay.
I tell my kids, I base my opinion off of somebody how I see them.
How many kids do you have?
2.
What are their ages?
15 and 8.
Okay, that's fairly close. So I'm going to pick on you. You come into the room and both kids are holding red markers. There's red marker all over the wall you just painted. And they both point the finger at each other.
And Steve Mullen's there with his full gear on, holding them back.
They're both guilty.
Who do you believe?
Both. They're both guilty.
Both guilty. Fair enough. Well, you know your kids, right?
Yeah.
You know their tendencies. I have 2 little girls. I know their tendencies when they're not being completely honest with me.
Yeah.
Now, mine are young enough, usually they've got big rings of chocolate around their face or, pretty obvious. But what kind of things do you look for in your kids to determine which one's telling the truth?
Like you said, eye contact. One of them would break down before the other one.
Right.
Or they'll team up and cover each other.
Cover each other?
Yep.
Now, you have the unique benefit in that situation that you know your kids. You know their tendencies. You know their habits when they lie, those kinds of things. You're not going to have that benefit here. And so each of you are going to have to determine what kind of things are you going to look at to determine whether or not the person is telling the truth. Mr. Appleton, I haven't talked to you. What kind of things are you going to look for?
I would mainly say body language.
Okay.
I mean, I think I trust somebody more that gave a straight up answer than someone who's kind of stuttering or cowering away from the microphone or keeping to themselves.
Sure. Would you give someone more credibility simply because of what they do? Say if they're a police officer.
No.
Okay.
I believe that creates unfairness.
Okay. I guess that begs the question, too, if you wouldn't give a law enforcement officer more credibility because of what they do, would someone give a police officer less credibility because of a negative experience that they've had with law enforcement? So has anybody had a negative experience with law enforcement where, you know what, I'm not going to believe the cops because I've had a negative experience with law enforcement? Okay? Has anybody been the victim of a robbery or have a family member that's been the victim of a robbery? What about Mr. Timko, tell me about that.
What about, have you ever been flashed by a former future prosecutor at a party?
Oh my God.
Oh my.
He was tried here in this court. It was years ago. He robbed my place and then he.
So you've been the victim of a robbery?
Yeah.
Okay. And you said it was years ago and it was here?
Yes.
In the experience of going through that and being the victim, sometimes when we have cases like sexual misconduct, rape, child molesting, if someone knows or had a family member who was a victim of those kinds of experiences or been a victim themselves, it's too traumatic of an event to be a juror on that specific case. And so that's a roundabout way of asking you, that experience that you had as a victim, was that such an experience where, hey, you know what? This hits too close to home. I don't think I'd be a good juror for this case.
I lock everything up now.
Okay.
I don't trust anybody.
Sure. Did the experience you had, well, was the guy or girl convicted?
Yeah.
Okay. The experience you had with law enforcement, was it generally a good experience or a negative experience?
Good experience because I knew some of the officers.
Okay. Anything about that experience that you had for that should cause myself or Mr. Manahan concern with you being a juror on this case?
I don't know.
Okay.
Truthfully.
Okay. If something comes up as we continue to ask questions, will you let us know? Only, and again, only you guys and girls can tell us whether or not you're comfortable with this or not. Again, you're all going to be good jurors. This just may not be the case that you're a good juror on. Okay? Fair enough. Thank you. I appreciate you being honest. What about, this is probably more uncommon. What about murder? Anybody had a family member that's been a victim or a close friend? Let's start with Miss Klingenpeel.
Yeah, my uncle was killed.
Your uncle was killed?
Yeah.
And was it here in Carroll County?
No, in Howard.
Not solved.
No, in Howard.
Howard County. And how old were you when that happened? When you were younger or when you were an adult?
I was an adult.
Adult. Anything about that experience so traumatizing that, you know what, I wouldn't be a good juror on this jury?
I don't think so.
Okay. Were you and your uncle close?
Yeah, he was pretty close to my dad, so.
Okay. Something difficult to go through. And again, as we ask more questions, if you find that, hey, it's too difficult, you just got to let us know, okay? Miss Moore?
In 2011, my mom was killed in a drunk driving accident.
Oh.
Okay.
I was 13.
Traumatic experience, right? Anytime you lose a parent, it's hard.
I think it was at the perfect age. I was old enough to understand it, but old enough to overcome it. So.
Okay. Anything about that experience where this is going to, that was such a traumatic experience that you just wouldn't be a good juror for this case?
No.
Okay. Any concerns that you have at this point?
No.
Okay. I want to talk a little bit. I kind of want to shift gears. Does anybody have any other questions about that? Okay. I want to shift gears from being a victim or knowing someone's the victim to what I call, or what I always refer to as, vulnerability. Does someone deserve to be a victim? Let me give you an example. My grandma, she's 89 years old. She's going to be 90 this year. They go to Chicago for basketball games once in a while. Not so much now, but once in a while they do. And let's say they get done with the basketball game at midnight at the United Center, which is in a little bit of a rough part of town. My grandma decides, before she gets back on the bus, she wants to get money out of the ATM for breakfast the next day. She walks a few blocks away from the United Center and at midnight gets money out of the ATM and gets robbed. Does she deserve to be robbed because she put herself in that situation? Miss Peters?
Yes. What was she wearing?
Kind of silly to go out when you're that old, right? Alone in Chicago at midnight, fair?
Yes, it would be silly, but you've got to have an aspect of you'll be safe or you won't do anything.
Miss Nice, what about you? You think she deserves to get robbed?
I don't think she does.
Okay, why not?
Because she's just thinking about money the next day. She's not thinking about the safety of, she's not thinking like, hey, I'm going to get robbed this time.
Well, she should have been thinking about that, right?
I mean,
She knows better.
she should know better, but she wasn't thinking of that. So,
Grandma put herself in that situation, right?
yes.
Miss Moore, what about you?
I think you should be able to go to an ATM or go out at whatever hour and still feel safe.
All right. Miss Dinger, can you think of an example where a victim knowingly puts himself in a situation where they should be a victim?
No. I think there's situations where you can put yourself in, and I preach to my children 24/7 pretty much, be careful about the situations you put yourselves in, because these things can happen.
Okay. I grew up in a pretty old school family, and a lot of times if I would hurt myself, they'd say, "You know better, right? You did this to yourself to become the victim. Don't come cry to me now." What do you think about that? Is there a situation where somebody can act so carelessly that they deserve to be a victim?
I don't know. I think it's splitting hairs, and I don't know how to answer it right now.
Fair. That's fair.
Don't talk about my hair.
What if I was doing something illegal? What if I was speeding down the highway and someone, it's going to be a bad example, but someone came out and T-boned me. But had I not been speeding, it wouldn't have happened. But then I become a victim. Deserve to be the victim at that point?
It would be tougher for me at that point.
Mr. Timko, I saw you shaking your head. What do you think?
I want to give you a hug.
Do I deserve to be the victim?
Yep.
Okay. Who agrees with Mr. Timko? Kind of. Mr. Appleton, what about you? What do you think?
I don't think anyone deserves to be a victim, but it's also a matter of your headspace and what situations you want to put yourself in.
Okay.
People with common sense know not to speed anyways.
Sure. Anybody have different thoughts? Miss Burkhardt, different thoughts?
My thought is that sometimes we get caught up into situations and they get out of control, and all of a sudden you're out of control and you can't make good decisions. And I think that's I'll leave it at that.
I'm not out of control. My license plate says the boss.
Objection.
Okay. Anybody else have anything different? All right. So just some final thoughts I got. And that's kind of the extent of my questions and the extent of my explaining the different, I guess, areas that we're going to talk about during the trial. But here's some of my final thoughts. With the charge of murder and with the serious charges that we have, sometimes people have trouble, whether it's religious convictions, personal beliefs, morals. They have trouble convicting people of a crime. So my question I'm going to ask each of you, if the state proves each element of each offense beyond a reasonable doubt, can you enter a verdict for conviction? Miss Peters?
Yes.
Miss Parsley?
Yes.
Miss Moore?
Yes.
Miss Dinger?
Yes.
Mr. Timko?
Yes.
Mr. Appleton?
Yes.
Miss Hayden?
Yeah.
Mr. Martin?
Yes.
Miss Klingenpill?
Yes.
Mr. Pancake?
Yes.
Miss Burkhardt?
Yes.
And Miss Nice?
Yes.
Okay.
Nice.
So if the state does meet those elements beyond a reasonable doubt, meets our burden, and you're firmly convinced, you can all enter a conviction for guilty. That's what you're telling me.
Yes.
Okay. This trial is expected to last this week and possibly into next week. It kind of depends how long it takes to get through the evidence. It depends on how long it takes us to select a jury and to get through the other things that we have. Is there anything going on in anyone's life right now that's going to distract them from being able to listen to the evidence for at least this week and perhaps into next week? Mr. Timko?
I work for myself, and it's the busy season. My head's not going to be here.
Okay. Tell me a little bit about what you do.
Lawn care and maintenance.
So we're just getting into the beginning of your season, right? I just mowed my yard, thank goodness, before the snow came.
Who gives a fuck?
And I'm way behind right now.
Okay, Mr. Pancake?
This Thursday, I have a sleep study test scheduled.
What the fuck? Okay.
Oh, we get some healthcare after all.
Just, I don't know how I'll do that. And,
Right.
this.
Okay, what time is that? From 8 at night until 8 in the morning? I don't have any idea.
I believe it's.
Yeah, it's about.
I think the check-in is like 8 till 4 in the morning or something like that.
Okay, and so Mr. Timko and Mr. Pancake, are those things going to be so distracting to you that you can't focus on the evidence that we're presenting and be a fair juror to the state or Mr. Manahan?
Yeah, I think so.
Mr. Pancake?
I think I can focus on the evidence. I just would have to cancel my appointment if I know.
Okay.
I'm going to be a designated juror because I don't want to distract from either one.
Sure. You have to tell us. It's okay if you are, but we don't know. I mean, we deal with a lot of farmers and people who own their own businesses. And so when we have a trial in the spring or in the fall for farmers, it's very, very hard for them to sit on a jury because those are the busy times of the season for them. We have a lot of small business owners as well. And, serving as a juror is not here to wreck your business, right? It's your civic duty, and we all appreciate your civic duty, but it's not here to ruin your life. And so you've got something like Mr. Timko's got, you just got to tell us. And so you have to be the one to tell us, hey, you know what, Nick, it's too much. I'm not going to be able to focus. I don't think I'd be a good juror.
I could focus if I knew I was going to be a juror.
Okay.
But if I was going to be a juror, I would cancel that.
Okay.
And
fair enough. And Mr. Timko, you're at this point, look, I can't focus on it. I've got a million things in the hopper, a million things coming down the pike. I run my own business. I'm going to be worried and focused on that and not on the case.
That's why I don't get to sleep till 3 a.m. in the morning.
Fair enough. Fair enough. Okay. I appreciate your honesty. All right. Has anybody served as a juror before? Does anybody know anyone else in the jury box? All right, Miss Peters, who do you know?
Jim Martin.
Okay, and who else raised their hand? Let's start with Miss Hayden.
I know Karen.
Miss Daniels, is that who you know as well?
Mm-hmm.
Okay, Jimmy?
I know her.
Okay, Miss Klingenpeel.
We've known each other. No.
Okay, anything about that give you concern about being a juror on this case? We've had a couple of instances where we got a husband and wife on the jury, and we had some concerns because if they disagreed, once the evidence was heard, if they disagreed, we didn't want to cause any kind of disruption in the family. And so the concern is, if you know each other and you hear the evidence one way and Miss Dinger hears the evidence a different way, are you going to be able to stand strong on your convictions and disagree with her and not just, I guess, agree with what she says because she's who she is? Does that make sense?
Yeah.
And since men are the head of the household in a house, in a home in Indiana.
This is insane.
Okay, does everybody understand that? We want to make sure that the other people you know aren't going to negatively influence you to change your opinion of what you saw at the trial. Is everybody okay with that? Okay? We touched base on this a little bit, but does anybody have any medical issues that would prohibit them from being a juror for the next week, week and a half? Okay, and the last question. Are all of you here in the box comfortable with being a juror on this type of case? I see everybody shaking their head. Does anybody have any questions for me about anything we've covered? I've been up here for about 45 minutes probably. Any questions about anything? Beyond reasonable doubt? Credibility of witnesses? Mr. Martin?
Is this murder? Is it like first degree, second degree, third degree, or
You've been paying attention? We don't have that in Indiana.
okay?
We have murder, and then we have, as I said, we have what I say we attorneys refer to as felony murder.
The royal we.
If a murder is committed or a death is committed while in the act of committing a felony, that's one kind of murder Indiana has. You have other kinds of murder, right? If I come up and I shoot you with a gun, you die, right? That's murder too. Okay? But we don't have first, second, and third degree like you see in some other states.
Did he mean murder as well? Or
Murder as well,
too?
Mr.
Oh, okay.
Manahan. Murder as well. But we don't have first, second, third degree like you see in some other states. They have that in other states, and they may have it in federal court, but we don't have that here. But the murder that we're talking about here, for the murder Miss Dean is charged with, is in the act of a felony, a death occur. What did I say about that? Tell me, Mr. Martin. What'd I say?
Somebody was, let's say they was robbing the bank, and like you said, they shot somebody, okay? Like the guy outside didn't actually do the killing, but they were involved. You're getting charged with murder.
Yeah, in for a penny, in for a pound. That's what I always say. If you're in a little bit, you're in for the whole thing. Everybody comfortable with that? Any other questions? That's a good question. We see that on the movies. First, second, third degree murder, right? In the shows that we watch. So, any other questions? Okay, all right. Thank you, Judge.
Mr. McClellan and Mr. Manahan, if you could approach the bench for a moment. Are you ready? I mean, keep going or?
No, I'm good. That's why I had to take that break.
Fine. And do you need a break of anything before you start examining?
1 minute.
That's fine. All right. We're going to take a brief recess. I know that you've waited all of the morning, and we appreciate that. We're in a big chunk after lunch, and so some of us need to stretch our legs and use the facilities. So during recess, please do not discuss the case among yourselves. Go to the jury room, use the facilities in the jury room only, and it will take some time. And once the bailiff notifies the court that all members have adequately stretched and used the facilities, we'll process. So we'll be at recess for just as long as necessary. Thank you. The court. Oh, back on the record. This case number.
Oh, sorry. Go ahead.
Are we gonna pause?
Do we want to take a minute?
Yeah, please. Can we?
Yes, I am shooketh. What do we think so far?
It's ridiculous.
It's ridiculous.
Your Honor, I have at least 5 other murder trials today that I have to get to. I'm slamming these things. Do you think maybe we could, or do we really want to take a pause? Okay, we could pause.
Yeah, for a second. I mean, no, we can keep going. I just wanted to just check in with everybody and see how we're doing. Are we good? Are we okay? Let's keep going then. Okay.
I just want to say I've been through lots of trials, like in several, I don't know, a couple hundred homicide trials. And yeah, I live in a big county in a big city. I find the interaction that he's having with the potential jurors to be really folksy and informal. And I think his examples are kind of strange.
Yeah.
I just expect, I guess maybe I shouldn't have expected the level of sophistication. I don't want to sound like a snob, but you know, I've never heard a prosecutor speak this way to the jurors especially in a homicide case.
You've been tried for murder 100 times?
No, I've investigated them. Thank you very much.
Oh, okay.
Do you think that so given like your experience and what you're seeing, reading, hearing, do you think that, I mean, how do you think he's going to do in a more urban, like bigger jury pool, like in Allen County? Like I feel like the folksiness will, I don't know if it'll fly. What do you think?
Yeah, I mean, Allen County is larger and it's a more metropolitan, but it's still Indiana. So I don't know. I think he's either going to piss off people with his folksiness and they're going to get upset because they're going to say he's trying to charm the jury. He's trying to get on their good side, whatever. Or the people are going to be like, whatever, just get this over with. I don't care. Now, if he were to go and speak that way and behave that way in a court in Indianapolis and Marion County, they'd laugh him out of the door.
Mm-hmm. I don't know. Yeah. I mean, I think it's a good point. I think that in Indiana, that urban-rural divide is not nearly what you would see in a lot of other states. Like a lot of people, even in Marion County, are still just regular Hoosiers.
Absolutely.
So what do you think about, so you got this trial coach, right? And it's not even somebody who has legal experience. It's a psychologist, right? So yeah, did you not know that? He hired these thousands of dollars he spent on a jury consultant and trial consultant. They are not an attorney. That's interesting, right? So that plus it's going to be a little bit of a different demographic. You see, he's really trying to play like the folksy uncle at the function, at the barbecue, just goofing. Is he going to try to be like a more urban audience, just kind of a thing? Like, is he going to really worry about how he's perceived to the audience if they're different?
Mr. Manning, about that. You're trying to suggest that Nick will rap?
Yes, I think he's going to do white boy rap from the jury and try to act like, those white dudes that code switch. He's going to try to do that to try to appeal to people. But I do think it's super cringe, but it may work there. But I don't think it's going to play that well. But at the end of the day, he's going to get a handful more preemptive strikes and he's going to get whoever he wants on this jury, basically, because the judge has an incredible amount of discretion and how they perceive a preemptive strike versus a regular strike. Mm-hmm. And they're going to get a ton of people disqualified because she's going to give them the benefit of the doubt.
Yeah, there will be no cameras. Judge Gold will be there. He'll be just fine. He'll feel right at home.
It will be interesting to see what his demeanor is in court after he's consulted with this jury consultant person, if he changes it at all, I don't know how effective. I know in larger cities and bigger cases, the jury consultants can be very effective and can actually make or break a case. So I just don't see that happening in Delphi.
I mean, I think that a lot of these questions are not really nuanced enough to really dig down and weed out some of the things they were like where people have a question like the difference between beyond a reasonable doubt and beyond all doubt. Like I don't think that they really did anything effective with the questioning. Like I think it was effective. We're like, hey, is anybody too busy to do this? Like that was just really practical stuff. But I don't think that I think it's pretty baseline stuff. And I don't think that it was really, you didn't hear anybody really give any answers, and which is, I don't think that you're going to hear it unless you really press it a lot more. And even when people gave some questionable answers to some of these things, they kind of just moved on, they didn't like, well, that's going to be a problem. You gave a problematic answer just now. And a couple times the people did, but
Do you think he's gonna use snowman example? Do you wanna
yeah, I probably do, because I've heard a similar type of example before, and I think that's often the type of example that they use to like start talking about circumstantial evidence about how do you know it rained last night if you didn't actually see it rain. The
snowman was
or granular for some reason, but
okay.
He said it was his favorite example.
His favorite. So maybe
he's an example guy.
Habits.
He loves these examples.
What's up with the unidentified juror that's just like, someone was trespassing in your yard?
That was my favorite part.
This guy, like that guy, maybe that's why he's unidentified, because he did get kicked out. They're like, nah, not you.
Somebody, you need a security camera.
Yeah, you need a camera, man. Someone's in your yard, bro.
Do we want to keep going?
Yeah.
Back on the record.
It's your show.
All right, let's keep going. I think this is where we get the defense gets to pick, lead the show. So
all right, back on the record. This is case number 08C01-2107-MR-2, state caption, State of Indiana versus Jennifer Dean. We are outside the presence of the jury as we took a brief recess to stretch our legs, etc. in the afternoon, the first break of its kind. During the break, the following information in general was brought to the court's attention by the bailiff. First, that one of the prospective jurors, I think Joe Massey, realized that Cassie Lane is his cousin. Secondly, that prospective juror with the last name McTeague, who has already answered a line of questions about her past, is expressing some extreme trauma by the nature of the case, given the fact that she has a family member that was a victim of a purported similar event. And so with that information, I would probably inform the parties that the first bit of information is of little concern to the court, but the second, I would likely be inclined to excuse that juror for cause if that's the juror's desire, which it was not expressly stated that that's the desire, but I'm assuming that bringing the information to the court's attention was a roundabout way of seeking permission to be dismissed from service. And so that information has now been shared with the attorneys for the first time. Mr. McClelland, we're outside of the presence of the jury. Does the state wish to make any further record regarding the...
No, Your Honor, just that the state has no objection for her being struck for cause.
Mr. Manahan, any record for further request for record making regarding this information?
No, Judge. I don't object given the nature of her past experience. That probably is prudent to go ahead and excuse her at this time, Your Honor.
Thank you. The court will instruct the bailiff to discharge juror with the surname McTeague, who's answered questions about her personal experiences in the past, and given the expected evidence and all other relevant considerations, the court is going to discharge that juror if it is in fact the juror's request, as the parties have been advised and voiced no objection to that course of action. The jurors otherwise remain at recess, and we will notify the parties when we are done, and we'll continue with the voir dire process. We will go off record. Thank you. Back on the record. This is case number 08C01-2107-MR-2, State of Indiana versus Jennifer L. Dean. Parties appear as before, and we are once again in the presence of the prospective jurors. We've taken a brief recess for the afternoon. We hope that now our large boulder has almost overturned one time, and we're going to get some momentum here quickly to hopefully complete the process of jury selection, which is our complete goal today. Hopefully we'll continue the voir dire process with examination of this by defense counsel Patrick F. Manahan. The floor is yours.
Your Honor, counsel, ladies, gentlemen, thank you for your time. I always make the promise. Rarely does it come true. I will try to get through the most salient points of what we're talking about today. Where to begin? Let's start with I want to start with some legal principles. The judge touched on them. I always touch on them. Mr. McClellan and I have tried a lot of cases together. I've tried a lot of cases, and I haven't seen the video that you folks saw, but there's always some things in there that make me wonder about just your understanding of what we expect of you, okay? And let me just say, first and foremost, the only thing we expect of you is to be fair and impartial and be attentive. If you can do these things, you could be a juror. So let's just start with that. The judge asked a question. Miss Dean, sitting next to me, it's clear to you that she is the defendant. Okay? Anybody have any doubt about that? Have you, Miss Peters, formulated any opinion about her guilt or innocence? Huh?
No, I haven't.
Okay. My mother's a teacher. It's a trick. She used to do it to me when I was growing up. Miss Parsley, how about you? Have you formulated any opinion?
No, I haven't.
Okay. When the court told you about the presumption of innocence, what the court is telling you is that she's presumed innocent right now, so she's really not in a neutral position. You take the scale of justice. She's down here where she is presumed innocent, and we're going to try to tip the scale in the other direction. Okay? That is what it means to overcome the presumption of innocence, and that starts with the production of evidence. So let's just talk about a little bit of that evidence. The state will produce evidence, and the state has to produce enough. We're going to take that scale from here to there, going this way, okay? And we talked about it's the state's burden. So with that, Kylie, Miss Moore, if the state has the burden, and that's called the burden of proof. What burden does that place on Miss Dean? Well, what obligations does she have throughout this trial from your perspective?
To be honest and prove innocence.
Oh God. Oh, okay. Okay, Miss Dinger, same question to you. What obligations does she have right now?
I don't think she really has any obligations, does she? Because it's on the burden of the state to prove.
Yep. Okay. And that's exactly right. And the state's burden is 100%, and that means she has no obligation. So how does that really play itself out? It plays itself out in that she doesn't have to call a witness. She doesn't have to produce a document. She doesn't have to say anything. And of course, as the judge has told you, she doesn't have to testify. So you're sitting here thinking, well, that's kind of an artificial system. And it is. It is an artificial system in that the state has the burden of proof, and it's theirs entirely. Okay. Mr. Timko, what about you? Huh? How do you feel about that? Is that the way you live your life? Somebody challenges you with something. Do you sit back and just sit there and take it, or do you strike back?
No, if I could.
Answer back.
Prove it. I'll prove it to them.
Okay. So do you expect her to prove to you anything?
Yeah, that she's telling the truth, that she didn't do it.
Okay. So you expect her to prove something to you?
Yeah.
Okay. See, a lot of things in there are open to a lot of questions, and we're going to talk about the truth here pretty quick. Mr. Appleton, what about you? What do you have for expectations for her participation in this trial?
I just expect her to prove her innocence.
Jesus Christ. Okay. Did you hear Miss Dinger's comment that the burden of proof rests entirely on the state of Indiana? Did you? So that means she doesn't have to prove anything. So just when we call a witness, we provide the evidence for some sort of proof, whether the state does it or I do it, but she has no obligation. She doesn't have to prove anything under the law as a defendant charged with a crime. Okay. Can you work with that?
Mm-hmm.
Okay. Mr. Timko, can you?
No.
No.
Yeah.
That's fair. I want you to know, ladies and gentlemen, that we want you to do the best to be honest with us. You're going to have to give us a whole bunch of opportunities if you're selected as a juror to ask you questions, to participate in a lot of different ways. But we can't get into that point unless you share your concerns with us, okay? It may be a bad thing to say, but I'm going to say it. I love Nicholas McLean. Oh, I'm going older. I'm going to say it. Most of the time, when we get into this situation and we're asking you questions, if the question's asked the right way, I could basically get an answer out of you, any answer that I want. But you know what? Does that help in any way? That doesn't tell us what we want. What we want, and when I say we, I'm talking about myself, counsel for Ms. Dean, not counsel for Mr. McLeland, as counsel for the state. We want you to tell us what you're thinking, not what you think we want. We want you to tell us what you're thinking, because ultimately, if you're selected as a juror, you're going to be back here doing the same thing. So what we need to know is what you're thinking. And I appreciate your opinion. I would venture to say that there are more people than yourself over the years that have felt that way, have not said it, and then have said it. And I so appreciate that. So is there anything the court could do to change you from your position that says she has to prove something to you? She has to prove her innocence. Is there anything the court could do, Mr. Timko, to change your mind?
Well, if there's evidence, she's got to prove it's not hers.
Oh my.
But again, you're answering with a question, kind of a same response as she still has to prove. My question to you is, does have to prove if the court tells you she cannot be held to provide blank, required to provide you proof. Can you follow that, or can you not follow that?
Yeah.
You can follow it?
Hmm.
I didn't do a very good job. Do you expect her to prove her innocence?
Yeah.
Okay,
Nice.
next juror. He's gone. They fucking want this guy, huh? Okay.
Oh my God.
Okay. Now the question always becomes, how much evidence must there be? How powerful is it? This is the old TV thing. Well, it's this or it's that, but there's some magic language in here. Miss Hayden, how powerful must the state's evidence be?
I mean, I think it has to have like maybe more than one.
Oh, Torsel said Timko wants out.
More than one
okay.
piece of evidence that would point in the direction of her.
Okay. Yeah, you think that would have to have at least more than one piece of evidence?
Yeah.
All right, Mr. Martin. What about you? We know enough of each other. You lived here in the community a long time. I've lived here a long time, maybe longer than you. Same question to you.
Can you repeat it one more time?
Sure. Reasonable doubt. Proof beyond a reasonable doubt. How powerful is that proof? How powerful does it need to be to reach that level?
Well, in my opinion, I'd say if on the scale from 1 to 20, it'd have to be 16.
Very specific.
Okay. How did you get to that? This is my favorite line. You better not fuck this up.
It's
Go ahead,
perfect.
the court.
80%. I mean, he nailed it.
Take a pause. So, just for context for everyone, this right here, Judge Diener's insertion of his own idea of what reasonable doubt means here, him saying it's perfect, 80%. This in itself, they appealed her conviction based on this comment.
Well, they should have.
Of course.
Absolutely.
Yeah. So just, I mean,
Good job.
there were three different issues that they brought up in their appeal, but this was really, really shit poor jury instruction. If Travis is in the chat, he's probably like pulling his hair out of his head, but I just wanted everyone to, DB, if you could move your bad legal take stop sign, because it's perfect 80%. I mean, he nailed it. Like,
Nailed it.
Nailed it. That's so bad. Okay. Anyway, we can keep going. I just wanted to like bring everybody. She's tore herself chest and jumped.
I mean, to give him some benefit of the doubt, like I think that maybe he's just like referring to the math of it, that it's like a solid 80%, but like to conflate that with
He did the math.
Bar for reasonable.
Mr. Manahan's like, how'd you get to that? And Diener's like, it's perfect.
It was a perfect call. It was a perfect call. It's 80%.
Anyway, we can keep going. I just wanted to bring that up because that quotation comes up a lot in the appellate documents because it's really a really bad jury instruction. Anyway,
really inappropriate.
Yeah. Okay. Proceed.
Beyond a reasonable doubt. I guess you'd have to define reasonable doubt.
Yeah, and that's the problem. We have a definition for you, but the definition just gives you more questions, frankly, than answers. And so it's left up to you again.
Okay.
So first of all, do you expect her to prove anything to you in this case?
No.
You're going to hold her to that requirement. She moved to prove something to you?
No.
Okay, let me give you an example. And this is what I think helps explain it in my eyes, because it's doing it a lot of years. It's been hard to understand. There are 3 burdens of proof in the state of Indiana. The first one is what's called the preponderance, and preponderance is 50% or more. It's the scales of justice. Okay, that generally comes into play in civil lawsuits. I could do something to my neighbor, and my neighbor sues me because I'm a little creepy boy, and I was looking in his sues me because I've damaged his property. For him, it was just a snowman, but for him to win a court, he has to prove by preponderance of the evidence, 50% or more, just enough for the tip, for it to tip. If he's done that, he wins. Okay, that's a preponderance. Trev says, yes, this is pretty distressing.
Yeah. That's one word for it.
Oh, Miss Klingenpeel, good afternoon. You okay today?
Yeah.
All right. You have any children?
Yeah.
How old are they?
23 and 31.
Young children.
What?
Okay, when they were younger. Okay, the state knocks on the door of the state of Indiana. Miss Klingenpeel, we're here to take your children away from you. And what the fuck? We're going to terminate your parental. I'm going to get serious. We're going to terminate your parental rights for the state of Indiana to be able to do that. How powerful would you expect their evidence to have to be?
Very powerful.
Why?
That's my kids.
That's right. That burden is called clear and convincing. Okay? Prosecutors hate this one trick, but it came from a prosecutor, and it's easier, and it's an easier example to make. Down here, the presumption of innocence. Ding, 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 0, 0, 0. Okay. Miss Hayden, what's this point right here based on our discussions?
What were those other
preponderance? I'm about 50%.
Yeah.
So if I'm going to win the civil case, then we're here, okay? Clear and convincing is in here. Oh, why is it so high? Because our founding fathers, our state legislators say that one of the most important things that any of us have is our family. It's very important to have a family. And if we're going to disrupt that family unit, we're going to take your children away. that evidence has to be powerful. Fair enough? Anybody disagree with that notion? Beyond a reasonable doubt is more than that. It's powerful. Mr. Pancake, should it be more powerful? What do they do? Why did they tell us it has to be that powerful?
I would think they have to have beyond a reasonable proof. Photos, bruises, admission from a hospital where things were being done, where the kids weren't being cared for as being taken care of as such.
Oh, shit. Okay, not on the record. Just to accidentally minimize that. Powerful, Mr. Pancake, such. Clearly, that would be exactly the case. And if they were going to take your parental rights away, but we're past that. Now we're talking about reasonable doubt. Why does the legislator tell us, and our founding fathers say, that it's not just clear and convincing that's required? Side note, this is something that's always important. This little point right here. You know what this is? 100% proof. And the state will tell you that there's nothing you can know with 100% proof. So we're dealing with between here and somewhere in here. That's the level of proof. Why is that proof so high? Why does it have to be higher than the state's evidence to take your children away? Why should it have to be so high? And if you don't know it, we've got to volunteer. Help us, please.
Because a lot of, I think, people's lives are at the hand of, so.
Oh, that's a good answer. That the founding fathers tell us that there's nothing more important to any of us than our liberties. I thought it was kids, the family, sir. So if you're going to tell somebody, you're going to take somebody's liberty away, there better be a reason for it. It's not about money. It's not about these things that can be replaced. It's about a person's liberty. That's why our system of jurisprudence is set up. That's what we got to work with. The whole point of the example is how serious this is and how important the evidence must be. So I'm back to Miss Burkhart. Good afternoon.
Good afternoon, sir.
Do you expect Miss Dean to prove anything to you?
Absolutely not. I think that the state needs to prove their point.
Sometimes there's a switcheroo that comes, and the switcheroo is I don't expect her to do it, but I expect you to it, Monahan. You expect me to prove her innocence. It's kind of a tricky question.
Oh, you tricked me on that.
Wait, what?
Because that's why we're also jurors, is to listen to what you both present as attorneys. So you almost like you put it back on me and my 11 other jurors.
And the fact that's your role as a juror.
Exactly, but when it's somebody's life, there's a lot at stake on this side too.
Oh, that's a good point. On this side, being
a juror.
Oh, sure. Yeah, I'm not a juror though, ma'am.
We're making life decisions.
Sure, yeah.
I make my decisions every day on my job, and it's about integrity.
Oh, okay. So back to my question. She doesn't have to prove it. Do I have to prove it?
Yeah, you do.
All right.
That's why you're representing her.
Okay.
That's why you have to just prove to them for her. Otherwise, she wouldn't have been arrested. I don't know that she's been arrested. We haven't been that far.
I would tell you that I appreciate your answer, but I think whether it's that it's her proving it to her, or her proving it to me, it isn't any different. But your answer is how it works in reality. That's how it works. Okay, let's jump into the next question. The next question is proof beyond a reasonable doubt based upon the number of witnesses. Is somebody just sniffling into the mic, or did they want to say something? Oh, okay. Okay. Doubt based on the number of witnesses that one side or the other calls. Ms. Burkhart.
I don't think it's about the amount of witnesses that are called.
Why not?
I think it's about the evidence.
Well, each witness would come in and they would have testimony, presumably, but you're right. It's not It's not the number 61, okay? And it's about what they have to say. That's really the most important thing. Does it matter to who calls a witness, Miss Burkhart?
No.
Same reason?
Same reason.
Okay, well, so here's a quick question comes. How do you evaluate Miss Nice, the credibility of a witness?
Just how they talk and that they are, say, like if they're nervous, if.
All right. Any other reasons or anything that are important to you?
Just how they just tell their side of the story, I guess, and what had happened. And if they keep on stuttering, it's just.
Uh-huh.
That's just a red flag for me.
Mr. Appleton, is there anything you would like to add to the answer?
I would say mainly body language, comparing witness statements if they happen to see the same thing.
So you're talking about corroboration. Do people say similar things? Okay, I saw it. This is what I heard. That helps. What about consistency, Miss Dinger? Is that important in testimony?
To me, it would be.
Okay, tell me how you're processing that in your mind so I can understand it.
I think the more consistency there is, knowing that an oath has been taken to tell the truth, then that would make me rely on that testimony and make me weigh that as a person is telling the truth, and then I'm processing the evidence in my mind.
Is this the consistency that gives you the feeling comfort, or is it the oath?
I would say the oath to me comes first.
Okay.
And then I would say consistency would be one of maybe some, I don't know. I don't know if I can verbalize it, but that would fall behind the oath to me, I guess.
Okay. So is it true then, Ms. Moore, that do you agree with some of the statements we've heard so far about weighing the credibility? So if we got any inconsistencies, is that the other side of the coin that says I'm going to start worrying about that?
It would definitely raise a red flag for me to pay more attention to what is so different about one person's testimony to another's.
Before I say I'm going to break and read this. Travis, a real attorney with a real attorney day job, says, "This is horrible, frankly heartbreaking how this defendant had no shot." What?
Yep.
Oh, okay. So this defendant had no shot of finding an unbiased jury. Need to see what he did with it on the challenges for cause, but this is pretty awful. Yeah. Yeah, Manahan isn't really. He's more of a wet handshake, or like a soft handshake type of guy.
Dude, he sucks.
Yeah, he's terrible.
He fucking sucks.
Well,
no offense, Stevie.
Take it back. Okay.
He's bad.
I'm going to go with my line here.
Okay, go ahead.
And I think that people can have two different testimonies because two people can be in two different places at one time given. So I think that it would just be in the moment. I would have to be there to hear what is being said, how it's being said, and then, just the amount of evidence that's given, I think.
And what about the oath? How important is that?
I would like to believe that everybody's honest in their oath, but I think that there's a fair amount of people that still lie under oath.
Sure. Back to the question. How do you know?
You don't.
Correct.
Only we can never get to that 100% like you guys have all said. So we just have to get our gut feeling and what we've been told, all of us together, and to make that final opinion on what happened, I think.
Okay. Hypothetically, it's important in these kinds of matters at this time. Hypothetically. Ms. Peters, you've heard testimony, whatever it is, and it's clear to you that it's inconsistent. It's clear to you that it's not consistent. And let's just start with that, okay? Does that cause a flag for you?
Yes, but I believe we have something we can do about that by posing questions.
Do you think everybody will answer questions truthfully?
Well, I would think that the attorney would answer truthfully.
Well, there are skilled witnesses that take the stand sometimes, and they may be able to
Yeah,
to be, as headstrong as anybody.
we really haven't gotten to that point.
Yeah, and that's the point. Can you take the time to not take things at face value? Because sometimes in a case, it's not always at face value. Do you know what bias is?
Yes, that's whether you sway one way or another based on both. Some predisposed.
Can you think of somebody that would have a bias in the trial?
Well, somebody might in the fact that she's a female and they see a female as someone who couldn't do something like that.
Fair enough. Anybody else think you might be on the bias spectrum? We need to at least consider. I bring it in the defendant's grandma, known her forever. Are you concerned about the grandma?
If there's an inconsistency, yes. If everything of her eye contact, her body language, I would think she would be nervous. Everyone would be nervous. I would think that she was consistent with everything. Everyone said then no.
Oh, I dropped my papers. 1 second. What pages are we on?
104.
104.
104.
Thank you. Thank you, both of you. Oh my God. I bring defense. Do you think there's anybody in this courtroom on either the defense side or the state side that doesn't want to win?
No. I think everybody wants to have the outcome that they're here for, but we don't have that predisposed outcome. We have the one who we are supposed to accomplish whichever side that we feel is the right side.
Which has been proven.
Right.
By preponderance of the, or by reasonable doubt, beyond a reasonable doubt.
Okay.
It's often said that the most biased person in the courtroom is in fact the defendant. Why would you?
But she's not.
Suggest that to be the case.
She's not getting up there, or if she's.
But why would they say she's the most biased person?
Because it's her life and her liberty.
She wants the outcome. Why wouldn't she? Why we shouldn't believe her? She's in here telling you the story because it's the truth. No, it's not the truth because she's biased. Okay, she's all that's going on, and same with the witnesses. There are all kinds of things going on. And what we ask, what Mr. McClellan asked, what the court asks, what I ask is study it and think about it. Look at it. Does it make sense? Is it practical? Can you do that?
I can.
Okay, perfect. Mr. McClellan, full of examples. Paint on the wall. We got kids put the paint on the wall. Okay, at my age, they're grandchildren. It's a lot different when they put it on the wall. Yeah, it is, isn't it? Tell me it's not. Miss Hayden, nobody fesses up. You've given them the evil eye. They're not getting cookies. Nothing's happening, and there's still paint on the wall. What do you do?
Make them clean it up, both of them.
What's that?
Make both of them clean it up.
Is there anybody in here that doesn't do that? Is there anybody here that just says, I can't tell? Everybody's guilty. Anybody that feels differently? So if you can't solve the problem, everybody's in. Is that the way you all feel? I will tell the court, since we're recording everything, that I see no hands. And so, to me, if I'm wrong, that's an indication that everybody gets hauled in together and everybody gets held in the same timeout zone, okay? If you can't tell in this case, what do you think your obligation is as a juror, Ms. Hayden?
It should be not guilty.
Right. So that's that example, that we all live with people, young kids damaging walls and things isn't necessarily you're going to be asked to do as jurors. You may want to arrest them for a capital crime, your grandchildren. You may come to the same conclusion, but because you can't decide, it doesn't mean that you go to other decision point. Does that seem fair enough to you, Miss Hayden? That's Miss Hayden, that everybody's responsible.
No.
If I can't tell, everybody's responsible.
No, it's their duty to prove it to me that she's guilty because she's already been.
Okay, can everybody do that? It's different than the paint on the wall. I haven't really got one for you for the snowman yet, but I've been working on it. Mr. Pancake.
Yes, sir.
I lied to you. It's proven that I lied to you. Can I ever fix it? Can you trust me again?
It would take a lot for me to trust you again.
Does the magnitude of the lie matter?
No, it's a lie.
It is a lie. Okay, Mr. Appleton, what about you? I've lied to you. What does it take for you to trust me again, or will you ever?
It would take some time, but I think you'd have to keep an open mind and try to trust you again.
Trust you again. Oh, I had your name down as Hauser for a while. Were you a Hauser and now you're a Nice?
Yeah.
Oh, okay. Can I call you Mrs. Nice?
Yes.
Oh, that's gonna be tough, huh? Okay, same question to you. If somebody lies to you, do you ever tell them the wrong last name, you little fuck? Oh, I mean, sorry. Can they ever make it right? Some people say you can't ever make it right. Some say, yeah, I expect it. You know, we live in a world where everybody lies to us. Can never tell what the truth is.
Right.
How do you feel about it?
Everybody lies, but once you've lied to me, I will second guess you everything you say to me.
Oh, Mr. Martin, question to you, sir. Is there anything about the charges itself that you have now got a strong feeling about, outcome of the case? Haven't heard a fucking thing. All you've heard is innuendos of the attorneys up here, asking you questions. You're kind of figuring out what's going on, but there's anything about murder case that says, man, we don't take those things lightly. She must have done something. Felony murder case. She's sitting over there with Manahan. Do you feel that way about this kind of case?
No.
All right, Miss Klingenpeel, what about you?
Right.
Okay, perfect. There are some cases that people would tell me that, but I am suspicious like jurors because I'm a suspicious person. And one of those things is sexual assault. Okay. Who in their right mind could ever support something like that? And when jurors come in here and they hear these things in the nature of the charge, I'm telling you what, that light's turned off and the presumption of innocence has gotten a whole lot different. Right next to our crimes of violence against individuals, persons. And so I'm concerned that it's just the magnitude of what's happened is so much that holding the presumption of innocence becomes difficult. Miss Moore, how do you feel about that?
I feel very confident that I can go into this with her being her innocent right now until I can prove it otherwise.
Okay, side note. That's necessary. That presumption stays throughout the entire trial.
Yes, and
he fucking side notes the presumption of innocence throughout the trial.
Sidebar.
I mean, and the courts.
Yes.
Okay, most of these things that their attorney's talking to you about are part of the instructions, and you're going to get them. But I promise you, when I read them, after time, what does that mean? What does it mean? You're going to want to know, but it goes throughout the trial. I believe that there may be, I think you said, did you say gory or graphic or something? Maybe some sort of that. I had a couple of trials where, people said I could do it. And then once we started, they can't do it. It's just too much for them. Is anyone in here concerned about that? Miss Klingenpeel, are you concerned about that? The pictures may be, there may be such that they're difficult. You going to be able to deal with that?
Yeah. I don't do well with.
Oh, you don't what?
I don't even like to look at dead bodies on TV. I just don't.
Okay. I would guess the nature of murder charge, you're going to see a dead body. And so the question is fairly put to you. Are you going to be able to process it for what it is worth, a piece of evidence, but not make so much that you lose sight on all other requirements of being a juror, being, fair and impartial, and following the instructions, the presumption of innocence, and the burden of proof? Can you do that?
I'd have to hold myself accountable to that, and if chosen, that's my job.
Okay.
I'm going to be honest. I'll go home and it will bother me. I might not sleep well at night.
Please, for what it's worth, most people have mixed feelings about attorneys, but I promise you, it's the same for all of us. It just is. It's a difficult thing, but you know what you think your role as juror is supposed to mean, Ms. Berg?
The role of a juror?
Yes.
Is to be fair.
Okay.
I mean, have integrity, to be listening to both sides with an open and honest mind.
Uh-huh.
And not have, I'm all about integrity and honesty.
Okay.
And I take things, but a juror makes decisions, and we make, and on this one, it's going to be that somebody's life is going to depend on the, for the right and having that, and it's going to be,
What? You're gone. You're gone. You can't do it. You're gone. Next fucking person.
This is insane. This is insane.
That was inappropriate of me. I apologize, everybody. That was inappropriate. I'm gonna be back. I'm back to Mr. Monahan.
Mr. Monahan.
Oh, is it me now?
It's you.
I was
Yeah.
being a little sassy bitch. Okay, sorry.
You're very
I would tell
sassy.
you that all your answers are correct. The other thing is that I would like to add is that it's not your job to solve the case. Okay. So if some piece of evidence becomes critical and we don't have that piece of evidence, it's not your job to speculate on what it is or how it should have been done. That's our job as attorney, state's job, to give you that evidence. So it's not, to guess. It's not to speculate. It's only from what comes from here and blah, blah, blah. I'd only known what would have been made if it would have made a difference. Okay.
Christine, here is your reminder.
Don't blah, 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 blah. Blah, 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 blah.
I'll be right with you.
DB, this is your reminder.
What?
I muted you. Oh, you're back. Okay.
Ding.
That wasn't me.
That was Mr. Manahan.
No,
Proceed, Mr. Manahan.
Oh, no, I was trying to cover up when I was talking for somebody else. You think somebody that's anti-government that is on the run from the feds would have Alexa in their house?
Seems kind of seems a little bit in conflict with, I don't know.
Okay, so
we'll check back in about that later.
Excuse me. So if there were some piece of evidence that becomes critical and we don't have that piece of evidence, it's not your job to speculate what it is or how it should be done. It's not your fault that the state lost it. That's our job as the attorneys. The state's job is to give you that evidence. So it's not a guess, it's not to speculate. It's only from what comes from here and indiscernible. I'd only known what would have made a difference, okay? And that's why the courts will tell you, you're not supposed to drive by the scene. You're not supposed to do your own research. These kinds of things, because your decision-making is based on what's right here, okay? For whatever it's worth, good or bad, indifference, insufficient, way too much, that's your role. Can you follow that?
Yeah.
Okay.
Is the answer I give.
Thank you. It's getting late. Oh, fuck. A couple of quick questions. Does anybody work second or third shift? Okay, Mr. Martin, what shift do you work?
Tonight would have been my first day, my first night from noon to midnight.
First shift, midnight. Okay. Noon to midnight. And do you work for like that for like 2 or 3 days and you switch again, or how does it work for you?
No, that this last week was my second week at this new job of COVID, and they shut the company down. So I started working for
goddamn mask mandates too. Fucking. Okay. So for the foreseeable future, you're working 12 to midnight, to 8 to midnight, whatever. What did you say it was?
He said 12 noon to midnight.
Oh, 12 noon to midnight. And you do that like what, 5 days a week?
6.
Oh, you got to do 6. Okay. So the question is, when will you sleep? And will the job schedule be as such? Because conceivably you could try to sneak the hours in. I'm done. kind of early at 5 o'clock. You go there. Yeah, you're a public defender, bro. We know. You could go in for about 4 or 5 hours or something like that.
Well, there's not much to do when you have at midnight beside go home and take a shower. I don't watch TV, so you go to bed.
And my concern is, will you have a problem coming in here having, again, tell me one more time, what hours did you say you work?
Noon to midnight.
Noon to midnight. Okay, right. So if we go until 5 or 6 o'clock, how many hours away from? Would you still try to go to work at 6 o'clock until midnight?
Mom.
You would?
Yeah.
Okay. When do you wake up?
Well, I haven't started yet, but as soon as I wake up, I would have to be here at 8 o'clock, so I'd have to get up at 7 o'clock.
Okay, and so what I will ask you is, would that be enough sleep for you? I mean, you're a mature gentleman. You figured out how sleep works. Would you be able to do that?
Yeah.
Okay, Miss Klingenpeel, do you sleep? How do you sleep? Do you have your hand up?
Yeah, I have 3 jobs.
Oh my. How about 4? I remember reading your questionnaire. You're busy all the time. When would you sleep?
Usually about 11 to 3.
11 at night until 3 in the morning?
Yeah.
Okay, well, that was a discussion earlier about people that have jobs and have commitments that are self-employed, those kinds of things. You kind of put yourself in the same position, working three jobs. You're kind of an employee for hire. Whoever will be kind enough to take advantage of your services. Is there anything about your work schedule?
What the fuck? I'm sorry.
How is it 3 weird motherfuckers, dude? You got the judge, Captain fucking Weird Pants over there, right? And you got 2 dudes like underlings in weirdness.
What is wrong with these guys?
I think not. Oh,
Look
go ahead.
at me. Oh my god, sorry. Okay. I think not. The only one we're shorthanded there, so it's kind of hard on one job. I'm not certified to cover it yet. Oh no, tonight.
One of those things we want you to know is, you understand, this is a terrible imposition on your time, and in this case, it's going to be going through a week. I'm pretty sure I've gone to Friday. Is there anything in anybody's job that says, as much as I want to do it, cannot focus? I just can't do it because of all the other commitments I have. Are you in that position, Miss Klingenpeel?
A little bit.
This is 1 second. I'm writing something funny in the chat. Okay. I heard a little. I didn't hear a lot.
I know, it's a little bit, yeah.
You don't hear shit, dude. Okay. But if I asked you to do so, could you do so?
Yeah, I'd try.
All right. Is there anybody here that's not a note taker? Wouldn't take notes? I submit that in most trials, there's usually points at times where notes need to be taken, because the longer the trial goes, what happened 3 or 4 days ago is going to be a little bit uncertain, and you're really going to be relying on your notes. Is there anybody here that would like to take a note because whatever reason it's not part of their personality? Anybody? All right. Well, you'll be given an opportunity to ask questions you want during the course of the trial. There's a method you could take for it. Imposes are as follows. You raise your hand. One of the attorneys is going to ask you, and you'll be given a piece of paper. You write your questions down. You take it to the judge. The judge reads it. He gets recused. We read it. It may be or not be given. Is there anybody here that could not ask a question? I don't like being out in front. I don't want to be singled out. Is there anybody that would be unable to do that? Miss Klingenpeel? Yeah, I don't like being in front of people now. Okay, you're sitting in the back right now. You're in a good spot. But if you felt it was important, and inevitably happens, the attorney just gets so focused on one thing that there's something that's really important. Could you ask the question if you need to, right? Write it down on a little piece of paper.
Yeah, if it's important.
All right. Do not be offended if the question's not asked, because the reasons why. There's reasons why. I can ask questions. Nick is gonna object because he's an objectionable person, and sometimes agreed. I gotta get the question in. This is a direct quote. I wasn't lying. I got to get the question. I didn't get mad, maybe upset, but that's the process. Okay, so just so people understand, that's the process. It's nothing personal. What did McClellan get? 45 minutes?
And we have to talk about that snowman.
I'm working on that snowman. I'm thinking it comes down to some bias or something. Somebody is throwing that snowman out there, and so it's all trash. Is what I keep coming up with.
Because he's a younger attorney.
What's that?
He's
What'd you say?
He's a
Oh.
younger attorney.
Yeah, you know what does that mean? Younger attorney.
Well, he's got those answers.
Okay. Do you guys have any questions? Any more questions? They said you'd ask questions if you had one. Yeah. Does anybody have any other questions?
I have a question.
That's not. Ask a question. Yes. What have you got?
Oh, I can't ask no questions?
Oh no, I'm kidding. Go
I won't
ahead.
ask no questions.
Please go ahead. We're trying not to, and I probably shouldn't do it, but
I just have to ask this one question because, things bother me.
I didn't know that, but I do know what bothers you.
And I'll be blunt about it. I'm kind of a straight shooter. The media. Of course, like you said, this is a murder trial.
Oh God. Question.
Would there be
No books. We don't read books. You're not writing any books. We can't let you do that.
Oh, I don't want to write no books about it.
Okay, well.
I just wonder. I mean, there aren't really too many murder trials in Carroll County.
Thankfully, that's correct, because we don't
All
catch
right.
them. All right. So, are you concerned that there will be media coverage, or so how you would handle it if it occurs?
Yes.
How do you handle it if it occurs? Is that what you said?
I usually go in the other direction.
Oh, that's what we ask you to do. And in fact, just a prelude to what happens at the end. When the case is over with, right? Before we get to that, when you're back in the jury room, nobody gets to hear what you're talking about. Nobody. Okay? But when you're done and you've rendered your verdict, you can come out and you may share your views, what happened. And the court will always tell you, share your own personal views. Don't share views that the others had, because they may choose not to speak. But you have no obligation to do anything. Just keep it quiet. And the wisest thing you do is steer clear from it. Most of the time, the court will tell you is not watch social media. Do not watch the TV. Don't read the newspaper. My experience has been it doesn't come up with much. It might. Carroll County comes out, once a week. I haven't seen Channel 18. It could, but we ask you that you do not look at it. And again, because, they're paraphrasing. They weren't in here and they didn't see the whole thing. You did. Okay. Hopefully it won't happen. I don't think it will, but thank you for asking. Judge, pass the jury.
Thank you. We will continue on with the voir dire process. The attorneys have some information that they will provide to the court, and once they've provided that information, the process will continue on repeat until we have selected the jury.
Oh my God.
The following prospective jurors are thanked for their service majority of today. I apologize for how long it's taken, but you're free to go. We can give you something for your employer if you need it. Stephen Pancake, I believe is the name.
Aww.
Thank you. William Timko, Beth Burkhart, thank you for all your service. You're excused. And if you need anything for work, we can provide it for you. Speak with the bailiff. And then, Madam Bailiff, if you can seat the next 3 prospective jurors. Thank you. You're free to go.
So, I think that's all we had divvied up today. What do y'all think?
I think it was a really good process. I think they got it all down really well. I think all 3 of them are quite professional, very experienced, and they're all very good boys that somehow grew up together and know each other.
Yeah.
I think there's only 132 pages left, right?
Jesus Christ.
You don't want to knock it out?
I think we should probably take a break and come back to it another day. I am kind of upset that we lost Mr. Pancake, though. He didn't make the cut for whatever reason.
That's so sad.
So is Travis still here? In the
And
chat?
this was a brilliant idea, by the way, as we prepare for the trial. That's crazy.
That's a great point. Let me ask the chat. What? So you think they're being folksy folks? Are they trying to? They try to be relatable, or does this seem more like a personality trait? Go ahead, chat. Or people on the panel. Sorry, go ahead.
I think it's a bit of a mix.
Except for Fiend.
Yeah.
This defense attorney, oh my goodness. I don't know if how many cases he's tried, but it does not seem like he has very much experience or just dedication to the case. He's just kind of going through the motions.
Yes, going through the motions all the way to the chief public defender's office, right? Now, Angel's done a lot of research on this gentleman. Well, okay, I don't know. That sounds like kind of bad, but you know what I mean. Tell us a little bit about this guy. Did he win an award recently? That's kind of a nice thing, right? Did somebody present him an award?
So the video we watched at the beginning of the stream, I'm going to play it again really quick, but it's interesting that the defense attorney Manahan, who I don't know what he was even talking about, but so this defense attorney has been a defense attorney in Carroll County for the longest of all the defense attorneys in Carroll County. He's been doing it for at least a decade. He's like their number one guy. He
wasn't a public defender, was he, in the case, or was he?
Yes. Yes, he's a public defender.
Public defender. Okay.
Yes, he is. And Oksana was absolutely right. It seems like Rosie's also. Hey, Rosie, it's nice to see you. Is it me, or are these jurors smarter than the attorneys? I got that sense too. Yeah, Pat Manahan has been a public defender in Carroll County for a very long time. He was actually a public defender when Nick McClellan was a public defender, and kind of like mentored him. And I guess, let me see. So I think like this might, okay, so just keep that in mind.
So, some of you know why we're here tonight, some of you don't. I know Pat doesn't, but all of us know how great attorney Pat is. He's been a criminal defense attorney for a long time. When I first came back in 2009, he was a great mentor to me. Had a lot of long talks with a lot of good advice, and now we're adversaries since 2018. And so I've always told him and everybody else, when I get in trouble, he's the attorney I'm going to hire. However, that's not why we're here tonight. Some of you may not know that way back in the 70s, Pat was a pretty good basketball player for Delphi Community High School. To my knowledge, he still leads Delphi with the most points scored. Now, this is before they had a three-point line. After the Peach basket, but before the three-point line. Okay. Now, I did a little research, and I tried to find the number of assists he had, and for some reason, I couldn't find it. So I don't know if they didn't keep it, or he didn't pass it. I'll let him tell that story. So way back in probably the fall of 21, Susan read an article on Facebook or online somewhere, and said, hey, we should do this for Pat. Which, if you don't know Susan means, you should do this for Pat. So I made some telephone calls, we filled out a couple applications, did what we had to do, and I'm proud to be the first to announce that Mr. Patrick Manahan will be a 2022 inductee into the Sports Hall of Fame. Yeah!
What? Sports Hall of Fame?
So, as part of that, Patrick, the Delphi Community High School was kind enough to give us a Delphi game ball, a ball that was used in an actual game last year. And we're going to pass it around. I want everybody to sign it. We've also got some flyers that talks about his statistics and everything that he's done in high school. There is a banquet in May where he's going to be inducted into a formal ceremony, and so we can pass the information about that around to you if anybody's interested in going. But I want to make sure everybody signs this ball, and I signed it before I got here. And what I wrote is, Pat, number 34 on your jersey, but number 1 in our hearts. Thanks for all the long talks, the intense battles, and the cold beers. Congratulations on your induction into the Hall of Fame. Your friend, Nick.
I really, really appreciate everybody coming out. It's good to live in a small community because this is the kinds of things that happen. People show up and share their life with you, and I've been fortunate enough to have that happen. Friends like all of you here, I know, I recognize that it's because of you that my life has been blessed, and I am so fortunate to call each and every one of you a friend. So thank you for coming out. Please enjoy yourself. Please sign the ball, and thank you for keeping the surprise. I absolutely had no knowledge. Susan, thank you. My
Well,
a small community like this, these are the things that happen. You get to fix cases with your good homie, the prosecutor, and yeah, it's just a nice little touch. And a lot of you don't worry about your dads anymore. They have had draconian sentences for carrying small amounts of drugs. But oh well.
that was the worst thing I've ever read. That was bad. That was really bad. I
think that you chose. I think you chose what we were going to read.
I did, but I didn't read through. I skimmed over a lot of Mr. Manahan's parts because I didn't anticipate them being the worst parts, and those were really bad. Like
I feel like DB knew. That's why he called Manahan right off the gate.
I gave him Manahan.
Yeah, I actually wanted to be the janitor. That was probably the smartest guy in the room.
Okay. I just feel like Pat Manahan, I don't know what he said. If I were a juror, I'd be so confused after listening to him. Like, I'd be more confused. Because they kept saying, like, she doesn't have to prove it, you do. But that's the same fucking thing, because he's her attorney. You know what I'm saying? And he wasn't correcting them. Like, why didn't he object or correct them at all? At any point? At all.
Right. And I guess he's not objectionable. But I just, a couple days ago, or a week or two ago, I can't remember when it was. Who fucking knows? I played the part of a gentleman named Brian Harshman, a detective for Indiana State Police. And I just felt like they were kind of the same rambling, like, difficult for me to read because it's not like normally how I write things or read things or talk. So it just seemed like they kind of talked the same way, where they just was like, it was like a tangent inside of a tangent.
Maybe they're used to texting.
That's true. What do you think, Christine?
I don't know. They were both pretty confusing in what they told the jurors. Now, remember, we haven't been privy, except for the first 3 jurors that were asked to go home. We don't know what they're going to do in terms of their challenges down the road, but I'm pretty flabbergasted that they didn't confront these people that were saying the most offensive things that it was just, I don't know how the jurors I don't know how they got any like real information out of that whole thing.
I don't either.
It was so confusing.
Right.
I don't either.
It seemed like they even contradicted each other at times.
They did. They literally did.
Yeah.
So what do you think about that, like in the backdrop of this being a felony murder case where she's not been alleged to have intentionally participated in a murder conspiracy, but that she participated in babysitting children? And this is the type of...
well, hey, DB, in for a penny, in for a pound. That's what I always say.
That's right.
That's a good saying.
Right. People say that, sayings are how we should like create our entire worldview.
This poor woman. That's how I feel about it. Fuck them dudes up there.
So what? I don't really know that much about this case. So I assume she was convicted then.
Yeah,
yes, she was.
Yep.
She got how many years? 70 years or something?
60 years.
And then it was appealed.
60 years. Wasn't even
60
there.
years, and the male co-defendant got, I want to say, 40 years.
Yeah, and he was the one who physically pled, and he was physically
beat
present.
the victim to death. Yeah.
Were they charged with actual murder?
Yes, he was. I don't know about the female co-defendant. I don't remember.
I know. I really want Courtney to help me go. She went through that like really pretty deep the other day because there was an interlocutory appeal that was certified by Judge Diener in the other co-defendant's case. I want to say like this month or something. Like that case is just, there's a lot going on in the co-defendant's case, and I don't quite understand all of it. But the fact that Miss Dean got 60 years and she wasn't physically present, whereas the individual that physically beat Mr. Smith to death got 40 years. It's like,
well, I mean, I think it's a entirely disingenuous presentation of what felony is supposed to be. Like the slightest, the slightest level of involvement is not the bar for it, and he repeatedly tries to make that claim. That's just not what it is.
Yeah, and there's an interesting fact in this case too, where sometime after the murder, there was Dean, the defendant in this case, actually found a wallet in her house and contacted law enforcement.
Yep.
And turned it in.
Yep.
That's why you don't fucking call law enforcement ever.
There's a lot of interesting if people are interested in this case, I mean, there's a lot of really interesting. I think we should probably, it would be worth going through it in the next few weeks, probably, because there's a lot of pretty wild shit in this case.
The one thing that struck me was there at the end when Manahan was talking about telling the jurors it's not their job to solve the case, and if there's not enough evidence there, it's because the state didn't do their job and to not go looking for it. And I just think that in the Delphi case, I can't imagine. Well, I don't know. After listening to these people, maybe I can, but I can't imagine being a juror in the Delphi case and just being presented with what we know now and not wondering, what about the cell phone stuff? What about the geo, what about, can't they find out where people's phones were?
Yeah.
I mean, there's a lot of problematic stuff with the Delphi stuff, even just the charging, because how, you're charging them with murder, but you're also charging them with felony murder. And you can see, the example of felony murder is okay, well, what's the actual theory of the crime? They're gonna have to present something to try to make this jury think something. We don't know what that's gonna be, but the two things are going to be in conflict of whether he's the killer or whether he's just incidentally involved in some way. And there's other people involved. Well, that raises a lot of questions.
Well, at this point,
they have a theory.
Yeah, I don't think so either, Christine.
I really don't think they have a coherent one.
Well, I think they definitely. One thing that makes me agree with you with that is they just magically hire Cicero in this year.
Yep.
Just this dude comes along and he just decides to just completely not take anything into consideration what was talked about the scene before, and he just, completely redoes the theory on his own. It makes me think that they may have had a theory before, and any examination of that theory made it fall apart quickly. So it seems like they wanted to get a new person in there to be able to testify to some of this stuff. But in this case, I think it's weird that, she's overcharged to get felony murder, but like she participated in an underlying robbery, right? Because, or underlying robbery conspiracy is what they allege, because she was babysitting children so that the others could go actually do the robbery.
Well, let's extrapolate to things that we know. We know Richard Allen was a dog walker. Maybe he was walking the killer's dogs while they so that they could go commit the crime. Is that the theory?
Objection.
Some bullshit.
Yeah, okay, so it is another thing. So Miko points out something good here, and Miko and I have talked about this quite a few times in chat. He says she is poor, uneducated, has learning disability, and all the things courts love to criminalize. Exactly. Why is there this idea that because you don't make eye contact, you're less credible? Now, a lot of people would say that when they're not good at making eye contact, I love eye contact. No, I want to stare you down. I want to look into your soul. Doesn't mean I'm more credible.
No difficulty believing that.
Right. And it doesn't mean that I'm more credible, less credible. No, it's just there's ways that people act that are different. And people criminalize
I hate eye contact. I hate it. There's a lot of neurodivergent microaggressions in this.
Oh, yeah.
Body language? Get fucked. Body language. Have y'all seen my body language?
Oh, I've seen. There's whole channels dedicated to your body language.
I know. I'm aware. I'd be fucked if we're going based on body language. Like, how can you possibly?
Well, here's the other thing too: is like you have too much body language, they'll be like, "Yeah, serial killer, dude." And I know you're joking, but like, that's exactly what they do. If they just want you to look guilty, you're gonna look guilty in their mind.
It's bullshit.
One thing I'll note that kind of came up with, like, you kind of saw it as a pattern with a number of the jurors. Like would you, like, who would be more credible? Like what's the bar of a more credible person or a less credible person? And repeatedly you hear, well, a law enforcement officer, I would say, is more credible. Okay, like, I don't know. It's likely something that is going to be a factor in with a lot of the witnesses being law enforcement officers.
Right. I was just going to say, think about the people that we know are going to be on the witness list that are going to be testifying. A lot of them are cops. And from what we've seen in that area, the vast majority of the residents, at least of Delphi, are on, believe the cops at their word. And
yes,
that's frightening.
It is frightening.
Maybe Allen County would be different.
It's very concerning because, like, the jurors aren't going to have any knowledge about this case, and like people with knowledge about this case will know for a fact that the tons of the law enforcement officers related to this case have just blatantly lied, like that they're not entirely credible, like, so. But they're not going to know that. They're just going to think these people are credible. So if they get up there and lie, they're just going to take them as credible witnesses.
Right.
Wild. I almost suffered my own. So when we were doing the snowman questioning.
What was the snowman's name?
Frosty.
I almost peed my pants a little.
That's funny.
I laughed really hard. Can you imagine being a juror and having to, like, take that seriously? Were they, like, what was that? He was just trying to, like, forced them to yield and agree with him. Why wasn't the defense attorney like, okay, enough? Like, are you allowed to object during
I
one?
don't know. I think that you can, but yeah, you didn't see any of that.
Not a single one.
Yeah,
Not one.
on either side, they just kind of both let them do their thing.
Well, Travis
but
said,
I think there was definitely some parts where you could interject and be like, this is not going right. This is
well,
this
Trav
wrong.
said at one part where Nick brought up his grandmother, Trav in the chat was like, that's an immediate like objection. And I don't know, maybe we can have Trav on this week whenever, but I would love to hear what he thought about all that. I mean, I know he said this is very distressing. Like very distressing.
And sometimes cops lie for each other, to each other and to themselves. Especially, you know, if you're a cop and you have a power over another cop, you can get them to do illegal things for you, and then you can, you know, they'll lie for you about it.
Mm-hmm.
You all just lie together. Oh yeah, lead with love. I got them laser beams.
DB's our bouncer. He's pretty good. I wouldn't want to be on. Never mind.
Unless I got top chat turned on and not all chat. You can get by me for a couple minutes.
Yeah, you were struggling for a few days there with that.
I thought we were not going to mention it on a live again, remember?
You're right. You're right. Homan. Ugh. Sit down, Nick. You suck. You'd probably get overruled. Man. Well, that was fun, y'all.
All right, I'm gonna finish the last 132 pages.
I don't think I can, Fian.
Oh yeah, no shot, dude.
But I think we should another night. We can do 100 pages a night. What do you think?
Yeah, next time some real bad state news comes out, hopefully, you know, we'll get a text to take over and you know, recraft the narrative and everything, and we can follow our orders.
Hopefully it'll be a little bit more interesting and less frustrating once we get to the testimony of the witnesses who did testify in the hearings. Because I know the female co-defendant did, and I believe the male co-defendant did as well.
Yep. Yeah, and Diener yells at him. He's so mean.
Yeah.
He's such an asshole.
I know.
He's so mean to him, which is interesting. Anne should wear a tutu so she can.
Oh yeah, I remember reading that. What the fuck was that?
Do it. I wish there were whistleblowers. Oops, I'm sorry. I have a Chrome extension.
Just Miku nerding out with me. That's a great Chrome extension.
Oh, you're just trying to justify your top chat.
Oh no, Miku is a fucking great mod and other real big popular channels. I'm just a mod over here, so
well, don't let us hold you back, my friend. Spread those wings.
And what TV's about on my channel? I don't know what he's talking about.
Yeah, what's the hell,
yeah.
Mandy, I think we should do more read-throughs this week. Who removed you, Miku? You're welcome here, Miku.
Rhymes with knob.
You're welcome here. You're welcome here in our family. Not a cult. Not a cult.
It's probably an interesting story behind that. Miku probably.
I don't know. I've been told I'm in a cult. So.
Not a cult.
Miku probably didn't yell at Bob's wife and disrespect her, so he's like, "You're out of here." Anyways, gotta go, guys.
Bob doesn't even read the chat.
For me for one day. If you're making spaghetti for the kiddos right now, I appreciate you. You cooking dinner.
Moms.
I think
now is where all the moms in the chat, make sure your volume's up. This is for you.
Hey, I know your feet hurt. You know, it's been a long day, and you know it's a tough job. It's a thankless job, but you know we appreciate what you do for the kids. So check the spaghetti, leave one out, maybe test it. You know, see if it's soft enough, and then get it going.
Sir.
Peace and love.
with that, on that note, oh, he Irish goodbye'd me on my own channel. I was about to say I am ready to. Hey, Zero Cool. I love that. If you rearrange the letters in police, it spells cops lie. Ain't that the fucking truth?
Wow.
Dinner was are we ready to Irish goodbye, friends? Is there any final thoughts, closing thoughts? I appreciate all of you so much for reading. That was a lot of fun, and I'm gonna go back and watch some of it because I laughed so hard.
Yeah, it's almost like
There it is. Christine, thank you. This was so lovely. I'm so glad to finally hear the voice associated with the funny tweets, the brilliant tweets. And
Thank you. Yeah, this was great. I appreciate you having me on tonight.
Yes, and we'll do it again soon. And if y'all want to read more of the transcript, we will make a plan to keep going because it doesn't get any better. It gets worse. It gets a lot worse.
Exactly.
So, all right, y'all. Well,
have a good night, everyone.
Good night, everybody. Bye.